Look at that house.
Legally,
She had her mother go by and take pictures of it. She was so emotionally involved.
Oh, my God.
4 under 7.
But it's not the style, it's not the floor plan, it's nothing. Oh, that I would have.
you must know my grandchildren.
They'd have to get a lawyer involved in that.
I should have
When we get them off, well, they're bad
done
enough.
something
Have
different.
these 3 cul-de-sacs.
Because the house was still in good shape.
Yeah.
No, it's a good, it's a good example of what we're trying to
Yeah.
create in the subregs later on in the agenda, to not have that
Location,
Yeah.
the
You
house.
get used to it. Yeah.
And we don't have any boys.
isolated
It is.
streets.
Good
That's one
location.
thing that worked out well for us, is being able to show the kids. I mean, there was no neighbors for kids.
Yep.
I just kind of think like
Yeah.
that. Run to school, run to soccer, all that stuff like that.
I want to call the January 18th, 2018 meeting of the Farragut Municipal Planning Commission to order. We'll start with citizens forum. That's where if anybody in the audience has a question or comment that does not relate to one of the items on the agenda, they can make a comment or ask a question now. Same thing with anybody on the Planning Commission. Or Mark, do you have any announcements or comments to make?
No, it's, the roads are better than they were last night.
Spud did a good job.
Silver spoons begin to.
Yes, so the clear, yes, yes.
And don't we have to fill out our annual?
Do. There's an annual ethics report that we have to fill out. We received it in the mail last month. It was bad timing right before Christmas, I thought. But it needs to be filled out and mailed into the state. Yeah, I was going to say you can do it online. And in the case of us, every year we lose our identification number or name or whatever and have to start all over again, so that's possible too. But that needs to be done. Do you know that when it needs to be done, Mark?
January 31st.
Okay, by the end of the month, so you need to get on with that. If you have any questions, I think it's fairly simple to fill out. My husband does it, so I don't really pay much attention to it. But we can ask, my husband or I can answer any questions, or Mark may be able to answer any questions. I'm not sure if they have to do that or not. You don't do that, so.
I just have to for AICP, but I don't have to.
But, so that needs to be done by the end of the month. Anybody else have any questions or comments now?
Where's mine? I haven't seen
You
it.
haven't seen one?
Yeah.
Okay. You need to call, I'll email you a phone number to call.
All right.
Okay. In that case, we'll move on to item number 2, approval of the agenda.
There's no changes.
Second.
All those in favor? Aye. Oppose? Approval of the minutes for the December the 21st, 2017 meeting. Any changes to that?
If there's no changes, I move to approve.
All those in favor? Aye. Oppose?
Abstain?
I abstain. I was not here.
You got those, Mark?
Yeah.
So in that case, we'll move on to item number 4, discussion and public hearing on a request for approval of resubdivision plat to remove the finished floor elevation, the FFE, and relocate the 50-foot building setback buffer as a measure from the sinkhole lip elevation for lot 60 in Unit 3 of the Sheffield Subdivision, .267 acres, zoned R-1 OSR, Ryan Lynch, applicant.
This is just a request to replat Lot 60. It's a lot that was platted as part of Phase 3 of the Sheffield Subdivision. It had a finished floor elevation on it because the adjacent lot, Lot 59, is an open space lot where there is an existing sinkhole. That's that inner line there on that lot to the left. The sinkhole ordinance, even the revised one, has provisions in there that the Planning Commission may revisit the 50-foot building setback that's from the sinkhole lip elevation if and there are certain conditions in the sinkhole ordinance that have to be satisfied in order for that to occur. The applicant made mention of that when this was originally platted back in 2016. If y'all, I don't know if you remember that or not, but they said they would study that area more and then maybe come back to you all at a later date when they had a report. So they had Geo's engineering do a report on Lot 60 that's included in your packet, and that is intended to support their request to amend that 50-foot building setback line. It actually would be roughly 5 feet from inside Lot 60 there shown on the screen. The town's planning and engineering staff did review this report, and we had the 4 recommendations that are at your places, but would recommend approval of this modification subject to those recommendations. It should be noted that they will have to have a finished floor elevation, even though the sinkhole is elevated above where the house would be constructed. When the sinkhole ordinance was amended a few months ago, we addressed a situation like that, and it just has to be 1 foot above the adjacent grade. So they would have to address that on their plat, but subject to those 4 items being taken care of, the staff would recommend approval.
Do you have any comments?
No, just that we're happy with the 4 comments, and we respectfully ask for approval subject to the 4 staff comments.
Okay. Any other questions or comments?
Mark, it says here at the end of comment 2, in addition, any alteration to the FFE standard would first require a separate variance from the provision of the sinkhole ordinance. Are you?
That's if they were requesting an alteration to
Okay,
that from
but
what
they're
the
not?
language is. They're not. They're going to adjust it per the amended language, is my understanding.
When we originally platted it, it was before you revised the sinkhole ordinance, and it said it had to be a minimum of, 5 feet above the lip elevation? Well, the lip elevation is 10 feet above the lot grade, and so it would put the finished floor 15 feet in the air. And so originally, that's what we were trying to get removed from the plat. But since then, I errantly came to BZA at that time, and then but since then, y'all revised the sinkhole ordinance to address situations where the buffer area in question is not within the drainage area of the sinkhole, and you just have a 1 foot. Now it reads 1 foot above the adjacent grade, so that's just finished floor a foot above the ground that you're building on, and we're fine with that.
Okay.
So
Any more questions or comments?
One of the recommendations, just for clarification, is that the report actually would be recorded at the Register of Deeds, and the report reference number would be added to the plat of record, so that if anybody buys that lot or does any work on that lot, they're responsible for following the recommendations of that report.
What hardship is the justification for the variance on the 50-foot setback?
I don't believe it's a variance. Your regulations allow for, with geotechnical investigation and an engineered footing, to build within the setback.
Engineered footing is being the key word there. Is that?
Yeah.
Okay.
That means with the permit application, the home builder will provide a stamped engineered footing rather than just following the minimum standards of the International Building Code.
Okay.
They'll actually have a design footing, and we did borings all the way down to bedrock so that the geotechnical engineer could make those recommendations on and the report also states that there's no greater risk of a sinkhole developing in this area than any of the other adjacent lots.
That language has actually been in, it was in the old sinkhole ordinance too, and we haven't used it that often. We did it in Inverness on a few lots in there, but for the most part, that provision hasn't been used by the Planning Commission. So it is something that would not require a variance if you all are in agreement with.
So basically what we're doing is we're saying we're defaulting to the opinion of the soils engineer, and that's what trumps the 50-foot setback in this particular scenario.
Yeah,
I'm thinking about somebody in the future coming to us,
Yep.
and how we're going to address that. And if we've got some clear-cut language in there that says, hey, if you're an applicant and you go to the length that this applicant did of hiring a geotech and doing a couple of borings and going all the way down to refusal, then I think it's pretty clear that we could be able to explain that to a subsequent applicant of, hey, this is the reason why they built within the 50-foot closed contour buffer, and you can't unless you follow the same conditions. I mean, I like getting an expert involved with this. Obviously, that's what it's all about, is protecting the homeowner and future homeowners. And I think there's by recording the document, that creates a tremendous amount of transparency for the public to understand when somebody goes, the subsequent buyer goes to buy that. They're being made aware, whether or not the real estate agent tells them they're aware of it, but they're going to find out through the title work that, hey, this is there. It's a public record. Because it does create some challenges. I've seen some transactions that get demoed because of even a little sinkhole contour coming into a corner of a lot and nowhere even close to the house. So, and that's really what it's all about, just making sure, hey, we've set up a good transparent process here, and we have something that's very black and white about somebody in the future coming and wanting to do the same thing.
Right. I think that your language is very clear in your ordinance regarding the steps required for this body to approve the action that we're taking here. Anyone else in the future would have to go through the same steps that we did to follow your ordinance, in my opinion.
So technically, we're not approving a variance. We're just approving an amendment to the original plat.
A revised plat.
That's right.
Yep.
The ordinance, because if you look at the stipulations in the ordinance itself, it's clear on the, do this unless, and then it spells out specifically the elements, and then who has to inspect and do the reports and everything else. So it's pretty clear.
We'll have to make reports throughout the house construction process, and we'll have to make sure that's provided to the town. And I'm sure they'll want to do that anyway, because they're the ones that have the liability if they're not going through the recommendations in the process. They don't want to sell something that somebody has some structural issues with because they didn't follow the recommendations of the professionals that did the report. So I'm not all that concerned about it in this case, but it's a good point, Noah, because it's something that we want to make sure we're not, creating some kind of approval conditions that we're not comfortable with, that others might come back to us and have brought before you all. So
I'm comfortable with it. I know when you get an engineer that's willing to sign their name off on it, they're a lot more of an expert than we are when it comes to sinkholes. So there's only two motions that we need tonight, or is it just one now?
just the one on the plat.
I'll make a motion to approve the request for approval of a subdivision plat, re-subdivision plat to remove the finished floor. Actually, we're not technically removing the finished floor elevation anymore, are we? So we got to be careful how I word that, because we've had a little bit of a change. What's the language in my packet? So do I want to strike that sentence and start over again? Is that correct, Mark?
I would say to adjust the finished floor elevation to the current requirements of the sinkhole ordinance or something like that.
I'll make a jump at this again. All right. Motion to approve the request for approval of subdivision plat to adjust the FFE to current regulations and relocate the 50-foot building setback buffer.
According to
Well, according to this particular,
four stipulations.
To the four subject twos.
Subject to
the four items as noted.
Okay.
Second.
All those in favor?
Aye.
Thank you.
Discussion and public hearing on a request for approval to amend the concept plan for Bridgemore Subdivision as it relates to lots that have been combined and how to calculate the permissible lot and building coverage. Placemakers No. 2 Partnership Applicant.
This item took a while to write, so I don't know if I can explain it adequately or not, but if I can't, Mr. Mormon certainly can. But one of the things in the R1 OSR zoning district that's been appealing and why a lot of people request rezonings to that is it does have a lot of flexibility. It has flexibility with coverages, and that's kind of the percentage of the lot that's basically in a non-vegetative condition, essentially, is the lot coverage. Building coverage is a percentage of the lot that's covered by roof structure. And in the OSR, it's based actually on the entire tract. There's a formula in the zoning district that addresses that. It's not based necessarily on individual lots, though it can be. Depends on how they want to address that with the plat. So when Bridgemore's original Phase 1 plat was recorded, it actually has, it groups lots, and it has different coverages for different groups of lots, and then they're based on the sizes of the lots with larger coverage allowances for bigger lots. The problem that we were running into is some of these lots get combined, and you may, and then you go back to the plat of record, and there's a little bit of uncertainty about whether you apply the lot and building coverages for the lot as the two lots for based on what those lots were on the plat of record, or if you can somehow combine the coverages for both of the lots, it would be permitted on the plat of record and address it that way. So the staff met with the developer and the surveyor to try to figure out a way to address lots that have been combined and not compromise the intent of the OSR for coverage. And what we came up with is we looked at the plat of record, and the highest coverage allowances for the biggest lots, we had 13,850 square feet for total coverage and 10,000 square feet for building coverage. So what we said was, if somebody wants to combine a lot, even if their coverage allowances are lower than that on the plat of record, you can add the coverages that would be allowed for each lot together, but they would be capped at those highest amounts that are on the plat of record. So nobody, even if you had two lots that were combined, still wouldn't be able to go above 13,850 square feet. That way, the intent of the coverage throughout the entire tract is not compromised. In fact, it's even a little lower. Because these lots are probably a little bigger than the biggest lots that were on the original plat of record. And you're not creating a situation where someone has a lot in the subdivision that has a coverage allowance much greater than what you see on the other lots. So that's what we came up with. We wanted that to be added as a note to the concept plan, and then it would need to be reflected on future final plats as well, so that we had some direction on how to address these lots that get combined. It's happened a few times in Bridgemore. People just want more space, a bigger house that can't fit on one lot, so they end up combining them, and they've been kind of held to that lower requirement that was on the one lot, not both lots. So I don't know if I explained that where you can understand it or not. It's a little bit hard to explain, but if you have any questions, I'll try to answer the best as I can.
I have a question about, are we talking any OSR district this is going to apply to? Or we're
No,
not
just in
talking-
Bridgemore.
Just to Bridgemore.
Again, that's one of the things with the OSR. You have a lot of flexibility. Some subdivisions, they just go with the standard percentage, 30 or 40%. Some of them have raw numbers. It's just however they want to deal with it, but they have to verify that they meet the requirements of the formula that's provided for in the ordinance.
Anybody else have any questions?
So, and this applies for the entire development, all phases of the development? Am I
It
saying
would
That
at
was
this
the intent
point.
by adding it to the concept plan, yes.
The only thing that may not apply if in the future on that concept in the northwest part where you got the real small lots, that's kind of a different design altogether. So I'm not sure how we'll address that, but
Okay.
it's
What
you know
was
what I'm
the
talking about, Benny? Those
Yeah, I do, and basically, they don't know That, if they decide to alter from that, in that area, they're going to have to come with a new concept plan
Yeah,
anyway,
that's
so we'll
right.
be revisiting it at that time.
Mark, what was the rationale why we would, if they had two lots, why we just didn't double their eligibility?
I think we were just trying to not create, because some of these things, I mean, you could end up with, 25,000 square feet of coverage if you did something like that, and just to kind of have some kind of limitation on it that
You felt like
you know,
that was
it wouldn't be
out of scale.
ridiculously out of scale, yes, with what, and I guess what we were thinking was most people combine lots to have more space, and if you're trying to create something that is visually out of place with what's around it, even if you have a larger lot, if you got all these improvements that are
Well, yeah. By the time you had driveways, and there was a circle driveway text amendment that was done a couple of years ago, so that adds a little bit more, and a pool and a clubhouse or cabana and things like that. I mean, you could add up a lot really quickly. So historically at Bridgemore, what we've done is we've just held them to whatever the maximum is for one lot.
Yeah.
Even though they assembled two lots into one. Okay.
Yep, that's right.
So we're trying to give them a little more flexibility without just doubling their eligibility.
Yeah.
Okay.
Yeah, we're trying to cap it, but give them the most liberal allowance based on the current plat of record.
We'll get back to compatibility.
Yeah.
I think the end result that you'll see is when people, the larger lots that have the higher values on them, those are starting to disappear. So if someone wants that environment, they'll be faced with purchasing two lots and can achieve what the product that has disappeared is.
Anybody else have any questions?
And this works for you? This is satisfactory for what you guys think needs to be accomplished in Bridgemore?
I think the developer was happy with the language, yes.
So you're still going to be held to the 13,380 total surface lot coverage as a maximum.
Correct.
Okay.
Like I said, where
Right.
this is really going to help is when there's some lots in there that might have
Well, you got, let's say 12,000 or
8,500 total coverage.
Right. Or 9,500 maybe.
And
Or
5,000 a building. If
Right.
they want to combine two lots and achieve what the 10,018, they can do that now.
Right. I got you.
Okay.
Any other questions or comments? Have a motion?
Motion.
Do I have a second?
Second.
All those in favor? Aye. Opposed?
Thank you. Thank you.
Discussion on amending action taken by the Planning Commission on June 21st, 1990, in relation to approval subjects twos associated with the final approval of Unit 4 of the Sweet Briar Subdivision, Town of Farragut applicant, and this is for discussion only.
Yeah, this was another one that was fun to try to write up. And I found out that part of my write-up is actually not accurate, and I apologize for that. It was based on the best available information that I had or could come across. So again, as this goes back quite some time.
That Ed Sinclair was here, but the rest of us
Yeah,
weren't
Ed was the only
born
one.
yet.
Yeah,
Tell us about it, Ed.
he's a legend.
Jack wasn't even born yet.
Yeah, Jack.
How's that make you feel, Ed?
Not doing something that's
Feel old.
dying, for God's sake.
So we do have some people that are speaking on this. It is just for a workshop discussion. I can give you just a brief overview and try to be accurate as best I can. Again, that is just going by the best available information I could come across.
Mark, could you and tell us where you weren't accurate in here so that we...
Yeah, well,
Thank you.
yeah, I can, and Carol
Appreciate
can
that.
too.
Point
If I
out
miss
your
something,
inaccuracies.
Carol can jump in on that. But again, this goes back actually to 1990 when Phase 4 for Sweet Briar was approved, the final plat. And there were 4 conditions of that approval. At that time, there was some tree planting that was required along Lot 56, and a paved parking lot of up to 32 parking spaces, a minimum 20 by 50 swimming pool, and a soccer field. And these things, other than the tree planting, were collectively referred to later as the recreational facilities, and they were to be constructed on that lot 57 there, kind of in the middle of the drawing. It's about 4 acres, 3.9 acres. So after the initial approval of Phase 4, Jerry McSpadden, the developer, he proceeded with house construction in that phase, and when they got to the last house lot, which is lot 37, the staff had discovered, was reminded that the conditions had never been, executed on the approval from the Planning Commission. So we, at that point, issued a stop work order on lot 37. They had obtained a building permit, but they hadn't actually started construction. And so the developer still didn't do anything on lot 57 and actually submitted another plat for Phase 5, and that's involved with Bancroft Lane, basically, is Phase 5. It was asked of the town attorney at that time, David Rogers, if the town could actually hold up Phase 5 until the conditions of Phase 4 were satisfied. His opinion apparently was that since it was not the same phase or unit, that we would be iffy as to whether we could do that. So the plat was allowed to proceed, and Mr. McSpadden built out Phase 5. The town did rescind the stop work order, but we, at the advice of the town attorney, but he did advise us that since there was a violation of approval from a town matter, that we could hold up on issuing a building permit. So basically lot 37 has been on hold ever since 1997. Well, since 1990, frankly, when the plat was approved. So lot 5, Unit 5 was built out, and Mr. McSpadden actually passed away a few years ago, and both lot 37 and 57 have been maintained by the estate and some adjoining property owners in Sweet Briar. There's an additional open space lot up in the upper left there, lot 76. That's a small detention basin area along Heron Road. That was platted as part of Phase 5, and it's also owned and maintained by the estate. At this point, the probate estate of Dorothy McSpadden, and one of the errors I had, I thought she was his wife, but she actually was Jerry McSpadden's mother, so I apologize for that. They're looking to divest themselves of the 3 lots that remain essentially unimproved. Only lot 37 is a buildable lot, as I mentioned earlier. Unfortunately, most of Sweet Briar predates the requirement that the town now has and has had for many years of a mandatory homeowners association, and the requirement that the town attorney review covenants and make sure they get recorded. That may have all come about as a result of this, frankly. I'm not sure, but anyway, so where we stand right now, I did talk with the town attorney, and he thought that since this was originally conditions placed on Unit 4 by the Planning Commission, that it needed to be vetted publicly as to where we go at this point. It's my understanding that Sweet Briar, another thing that I had in there that wasn't accurate was that there was no homeowners association. There was a homeowners association for Unit 5, but apparently it's now defunct. And it had, at one point, some language apparently about the maintenance of the 2 open space lots, 76 and 57. But I don't think that's active anymore. They can speak on that if they want. So Sweet Briar has a voluntary homeowners association membership, and they don't have a lot of money, obviously. So I think at this point, the town is not interested in obtaining the land. I think from our perspective, it would be good for the estate to try to, and I think they have been, work more with Sweet Briar and see, if they can come up with some kind of plan. I don't think the original conditions that the Planning Commission stipulated the approval on are realistic, given the financial means of the parties involved, because it would be quite expensive to construct all those improvements at this point. I also don't think that the Planning Commission should just waive any requirements on Lot 57. I think that we have open space requirements that were in place then and are in place now, and there needs to be some kind of useful improvement to Lot 57 in the staff's opinion, but certainly there's a lot of options that the subdivision regulations provide for that are varying in terms of how expensive they would be, and staff certainly would be open to seeing whatever they could work out, and then they would come back with a plan to present to the Planning Commission to see if you all would reconsider different conditions on what was approved. So that's my best effort at trying to explain this, and I do have some people that have signed up to speak on this. I don't know if you all have any questions of me at this point.
I do. Before we get into the neighborhood people asking some questions or making comments, why is this something that the Planning Commission is looking at?
Well, when I talked with Tom Hill about this, we always like things to be out in the open, and this was originally conditions that were placed on this subdivision by the Planning Commission or by the original developer. He agreed to as part of the plat approval, but he never did execute it. And I think to modify that needs to be, that modification, at least from our perspective, needs to be from the Planning Commission ultimately. But we wanted it on the agenda tonight just to basically inform you of how we got to this point, so that you, when it does come back to you at some future date, you'll have more information to make a better decision on how to address this.
So we will have to change the language about a pool and clubhouse and all of that sort of stuff. Is that something the Planning Commission
Well, I think
would do?
that's what would need to be presented to you. Yeah, as an amendment to those conditions.
It's kind of like we're at a fork in the road. We can either hold to the original language and let them,
Yeah, you don't have to
deal with it
amend the
legally.
conditions.
or let them come to some kind of compromise and come
Yeah.
back to us for a change.
Yeah, you
That's
could
the two
do either
choices.
one. Yes. Yeah. Yep. You don't have to modify the approval conditions.
Does anybody else have any more questions before we go to the neighborhood?
I'll probably, you want me to just call out people that have signed up first? Okay. I have Kathleen Keegan. You're not talking? Okay.
Mark, would we traditionally listen to the applicant first and then have, that way the applicant could do their presentation, assuming the applicant's here?
Well, we were the applicant. Yeah, we were the applicant only because the Planning Commission had the action, and we wanted to bring it to a public forum for
Okay, so
discussion.
it's not somebody here representing the McSpadden
I think
family?
both, well, there might be, yeah.
There's somebody here representing the association.
Yeah, they were notified, obviously, of this. We wanted them here, but we wanted to hear all perspectives so that you all had good information. So if you all want, we can have the estate speak on that matter first. I'm not sure.
I guess we'd like to hear what maybe the estate's goals and objectives are first.
Okay.
And then hear what anybody else that would like to share their concerns are. Or thoughts?
Good evening. My name is Robin McNabb. I'm here from the firm of Wise and Reeves, and we are representing the probate estate of Dorothy McSpadden. Just to clarify the family relationship, Dorothy was the wife of Claude McSpadden, and Jerry McSpadden was their son. So that explains where the confusion lies there. Mr. McSpadden died in about 2011, and then his wife passed on after him, which is why we're representing Dorothy's estate, not Claude's. And what's happening now is we're in the process of trying to divest the estate of some properties in the residuary estate that are basically costing the estate money while there's a pending will contest. So we're not at the point of being able to close the estate yet, but as part of working along that line, we're trying to get rid of some of these properties. The two common areas, as we've been aware of them, our intention was to try to deed them to the homeowners association, because that's typically what happens with subdivisions, is that at some point the developer conveys those and the homeowners association begins the maintenance responsibilities. As Mr. Shipley already explained, though, this is a bit of an unusual situation because there's not a firm homeowners association in place that collects dues on a regular basis. Therefore, there's an issue with how they pay for the property taxes, how they pay for the maintenance that the estate's been paying for along this time. And I did talk with Carol, and she's talked with some of her board members. I think we've reached an agreement where some members of the subdivision that have an active HOA, although not a mandatory HOA, are willing to accept those properties from the estate and assume the costs of maintaining them.
I don't think so.
Okay, I'm sorry. The last time I spoke with Carol, I thought that was the agreement we'd reached. Okay, I take that back then. Basically, we are looking to honor whatever there was in terms of the obligation to convey the properties to the HOA. The other alternative for us, there's not money to build a pool or build a clubhouse. We have the one other lot that at some point we're going to have to do something with, and obviously we don't want to sell it to a third party without knowing whether it's going to be buildable or not, because that will affect the value. The problem that we will have if there's not an agreement with the subdivision HOA is that it will end up getting conveyed to somebody, and the other heirs, aside from my client, who's a personal representative, are going to try to sell it and are possibly going to mount a legal battle on whether the Planning Commission had the right to impose those regulations or has the right to impose a no build on the other lot based on the law in effect at that time, because that's 4 acres and it looks buildable. And we've already talked with one of the heirs, or the attorney of one of the heirs, who said, well, if you think you have to give it to somebody, give it to me and I'll try to sell it, and if I can't sell it, then we'll deal with it. So
When you say other lot, are you talking about 37 or 57?
37 is the buildable lot. And 57 and the one on Heron
That was the
Drive.
larger, that was like the 4-acre lot.
But, yeah, 57 is the 4-acre lot, right. And my client, who is the daughter of the McSpaddens, granddaughter, excuse me, we had no knowledge of a requirement to build the recreation facilities. There's nothing of record. There is a common area reference on the plat. There is no master deed for Unit 4 that imposes on the developer the obligation to build these improvements. The last time I'd spoken with Carol, my impression was they did not have the means to maintain any improvements, even if the estate had the ability to build them. It's expensive to maintain a pool. It's expensive to maintain a clubhouse. So I thought we'd reached an agreement. I'm sorry if I misspoke, but our intention is to convey them, and if they're supposed to go to the HOA, we want to convey them to the HOA, and then we would also like to be able to sell Lot 37, which is the one that is not the common area, to someone who could build on it. Absent that, our options are to convey it to somebody and let them fight that battle with you all to see what can happen, or just let it stop maintaining it and let it escheat to, I guess, the assessor if we don't pay the taxes, which is not what we want to do. But they are costing the estate money. Our obligation is to get rid of them. Our question is just who gets them, and we'd like to do that in the way that is most fair, which would seem to be letting them go to the HOA.
Hello, everybody. It's good to see you all this year. Carol Christofferson, 11320 Gates Mill Drive, I'm the president of the Sweet Briar Homeowners Association, and I have with me 2 board members and a couple other homeowners, a former president, and of course, Ed, who remembers all this from 1990, right? It is very complicated, and it's also put Sweet Briar Homeowners Association into a very awkward situation. It's a very uncomfortable place for us to be, to have this beautiful 3.9 acres of property that are smack in the middle of what we call the new section, and it's been that way now for over 20 years. And we don't, because of the way that McSpadden set up all the homeowners, all the various, units, we do not have the ability to set mandatory dues in what we call units 1, 2, and 3, which are the 150 houses that are in the older section, and we spend probably 50% of our time scratching and clawing to get homeowners to give us $35 a year to pay for the upkeep and maintenance of the main entrance, which is in Unit 4, which was built when Unit 4 was built, which is the 2 streets down at the end of the new section. And McSpadden set it up so that we, 1, 2, and 3 can have nothing. I have in the articles, Article 4, and I will read it if I need to, will have nothing to do with the homeowners association associated with Unit 5, which are the 30 houses on Bancroft. He set it up so that those houses, which you all approved, which I wouldn't have done if I were you, that they are responsible for the upkeep and maintenance of the common property, basically the 3.9 acres. And that they are also, later on in here, responsible for the upkeep and maintenance of the main entrance, not Unit 4, in which both of these 2 pieces of property are, but Unit 5, which is the street down. So you're looking at, when we did the math, you're looking at close to $6,000 a year in maintenance of the common property and the taxes and the maintenance of the main entrance for these 30 houses that comprise Unit 5 homeowners. There is no Unit 5 homeowners association. We went through CAGIS and found that it was formed in the spring of 1998, and it was dissolved the winter of 1999, and there were never any dues. There was never any homeowners association. It doesn't exist. So the voluntary homeowners association, which is comprised of 1, 2, and 3, have been basically maintaining and taking care of these properties. There has been sort of a joint, I think, over the years, who mows that 4 acres. I think we've mowed it sometimes. I think you all have mowed it. But there's been no, no improvements. We cannot afford to pay the maintenance and upkeep on this property. And we feel that it's an undue burden on us to have to let this property be just given to someone else because we've been put in this position based on the homeowners' rules and regulations and covenants that supposedly you all approved somewhere along the line. I will mention that Unit 4, on which both of these 2 pieces of property are, has no covenants. They do not exist. We have a draft. It was never sent to the state. Ken Shipley and I have gone to the state 2 or 3 times looking for those. They were never filed. So anybody in Unit 4 can do anything they want. So we're in a bit of conundrum. We feel that the town should help us resolve this issue. It is open space that you all designated. We don't want houses in there. It would be very awkward, of course. We would like for it to be maintained as open space, which I suspect all of you would too. I mean, it is on your list of open space properties. And so we're coming to you to see if there's something that we can all come to that's a win-win-win situation. I will mention real quickly, if you'll look at that little tiny retention basin that abuts Heron Road, do you see that? That's 2/10 of an acre. I have talked to one of the homeowners, the other one's out of town, she doesn't like snow, and he is more than happy to take on half of that retention basin, the other homeowner take on the other half of the retention basin, and we can get that off the books. They will take it on as part of their property. They'll pay the taxes, it's $20 a year, I believe, to keep that as a retention basin. The only thing that the owner that I talked to said, well, if he was willing to take this on, he just didn't want to start hearing from the town that he was supposed to be doing something. That retention basin, as far as I know, and as far as everybody I know, has never been touched. No one has ever mowed it. No one has ever cleaned it out. No one has ever done anything in there except throw the dead animals that are on Heron Road. That's the only thing that's ever happened in there. So there is the precedent. We do have a large retention basin on Gates Mill Drive that was split, and one homeowner took half of the retention basin. The adjoining homeowner took the other half, and it's a beautifully maintained retention basin. So we'd like, and I don't know whether we go to the estate or whether we go to you all, I'm not sure how we do this, that we just get that off the books, that we take that 2/10 of an acre and split it between the two homeowners which it abuts.
Would you say, taking, are you talking about responsibility, or you're talking about quit claim?
Quit claim.
Okay.
Yeah. Take it on. Quit claim. So we'd like to be able to do that. I have not talked to Robin about that. It's a minor issue in this other thing, but it would be nice to be able to just get rid of this. One of the things I've been admonished not to bring this up, and I've decided it really is important. I have been looking for months and months to prove what I'm about to say, but I don't have a piece of paper that proves it, so you're just going to have to take it. When Unit 4 was built, of which there are roughly 30 houses, it's been said, it was in the newspaper, and homeowners keep saying this, that they paid $1,000 at closing when they built their houses towards this pool complex. Now, that means that the developer got many thousands of dollars to build this pool that never came to fruition. And I'd kind of like to know what that is all about. We're looking for, the Homeowners Association would love to be able to take this property on. We'd love for Robin to be able to give it to us, but we can't afford $3,000 in maintenance and upkeep. We'd like to have some kind of an escrow account to pay that, the taxes and the maintenance. Now, ideally, what we'd love to do, and you all have done this for us in the past, I'm just laying everything out here, is that the town take on this 3.9 acres and take on the maintenance. You wouldn't have to pay taxes. It's close to $500. I think it's $467 a year in taxes. That you all take it on and we make it into either a field, open space, however way you would want to see it, or my suggestion is that we ask the estate to plant a fair number of indigenous trees and put those on the property and turn it into a decent forest, taking up all the trees that we keep cutting down around here. This is an opportunity to replace them. So that's just one idea of what we might be able to do with the property. But we would be happy to have the township take care of it. You all do that with the other piece of property that we have down on Gates Mill. How many acres is that, Mark? 2.5, Ken? Thank you. You already do that, but you all seem to be extremely resistant to taking on another piece of property to maintain it. I understand that. So, anything else?
Let me,
Carol, can I ask you a question?
Yeah, hold on. Yes, sir.
Can you clarify the status of the homeowner association? When you say the homeowner association, is it still back just to unit 5?
No, we have a
You have a whole unit?
We do have a homeowners association, of which I'm president, and we pay the state. It's not a corporation. It is a corporation. It is a corporation. Yeah, we're a 501c3. Yeah, and the homeowners put it together. McSpadden would have nothing to do with this homeowners associations. He hated them. But we do have a valid homeowners association with officers, and we're having a meeting on Saturday, and it's a viable association. It is primarily supported by units 1, 2, and 3, but no, there are everybody. Okay, I take that back. There are 150 houses in units 1, 2, and 3. There are 60 houses in 4 and 5, but there are a lot of, I stand corrected. There are a lot of homeowners in 4 and 5. As a matter of fact, 4 and 5 seem to think that they belong to our homeowners association, which technically Unit 5 doesn't, but we are all, as far as I'm concerned, one neighborhood.
And Unit 4 has the mandatory requirement of membership.
No, Unit 5.
So Unit 5 has the mandatory requirement
Right.
of membership.
Correct.
It's the only one that
That's
has.
the only one, and it does not, the pieces of property we're talking about don't even exist in Unit 5. They're in Unit 4.
well, lot 76 is unit 5, actually.
Yeah,
And that is a detention basin. That was
The two
platted as
tenths.
a detention basin lot.
Right.
So
I
if they do
apologize,
modify
friends.
that, it would have to be replatted.
And it'd be
You
kind of
know.
weird running a property line down the middle of the detention
And
basin.
I don't
Go
know,
back to my question.
yeah.
Is the homeowners association for Sweet Briar a legal entity that represents the entire subdivision, all units?
Well, I don't know the answer to that. I don't think so. Ken, I mean, Unit 5 originally had its own, in its covenants, has a separate homeowners association. So does Unit 4. It just doesn't
But
exist.
I don't know what's happened in the meantime.
Yeah.
Carol's Family Dude, Ken Shipley, 11602 Gates Mill. Been there since '87, and there's people been longer than I have. It's entirely volunteer. We have had in the past people up and down Heron Road that were not even in Sweet Briar join our homeowner association just so they could keep up to date on events around there. So it's an entirely voluntary association. Somebody in Unit 1, I blame it on John Hoffman. I think they got together. They were mad at McSpadden at the time. I think they formed their own Unit 1 homeowner association at the time. It was in 1980, about the same time Farragut formed, maybe even before. And so it's been in effect as a voluntary homeowner association. We invited anybody that wants to join, but basically it is 1, 2, 3, 4, and 5. And you're right, 4 doesn't have any covenants. 1, 2, and 3 have got all the same covenants. The only thing they do is change the dates on them. 5 has a 12-page covenant section. It's huge, totally different, and they essentially put all of the problems associated that they'd ignored 1, 2, and 3, and 4 and put them in 5. And that's essentially what happened. But of course, the Unit 5, McSpadden and them created the corporation in 1998, and Tennessee dissolved it the next year because they never did submit an annual report, they never did submit bylaws, they never did have a meeting, so it just went away. And they never collected any dues either, as near as I can tell.
Well, there are never any officers. There's nothing ever set up.
Marshall's in Unit 5.
Well, even though there are separate covenants, have you all pursued anything of trying to have I'll say a minimum set of commonality across and set up for your homeowners association, the legal documentation that spans all 5 units, even though there's different covenants within each?
Yeah, that's great. We don't have any
I'm
money.
just asking if you have
Yeah,
been pursued.
we
at
don't
all.
have a lawyer.
Nobody even read the covenants till
Yeah.
a couple months ago when Robin called us I had never even read the Unit 5 covenant.
And most people in Unit 5,
Unit 5 hadn't read the Unit 5 covenant.
real estate agents in this town get away with murder because they don't even give people the covenants.
Or change it where you have some mandatory dues with the sale of a property.
We would have to
I know
change-
Older subdivisions have done something.
I
Yeah.
started to say, my neighborhood was in a similar situation. We had no
HOA?
organized, approved homeowners association. And they have since then organized, we still are voluntary money collection. That's still voluntary. And we do maintain the property and we do maintain and pay the taxes. And if you'll leave me your phone number, I can have our president call you and tell you what they have gone through in the last, I don't know, 10 years or so to get all of this organized.
Well, I will say that the covenants for 1 through 4 are almost identical. I mean, I think they are identical.
Said there's no covenants for 4.
No, the draft.
Okay.
The draft covenants that we have in our file that were never signed and never submitted are identical to 1, 2, and 3, except that I think the footprint for how large a house can be was a little bigger. That's it. So 1 through 4, in terms of covenants or non-covenants, is not the problem. It's all very similar. We do have problems with how big a garage can be and all that kind of garbage. But it's the mandatory dues versus the voluntary dues that is the single biggest issue. You can't.
How I know that has been addressed, it's been addressed in our subdivision, is that when the majority, voted to have, when it's all voluntary and it's slowly rolling over, it takes time, but you can come back and say, okay, upon the sale of your house, your grandfather, but when you sell your house, that's a mandatory requirement.
I'm pretty sure that's what my neighborhood
You have
did.
to have a framework.
Sugarwood did that too.
You're going to spend some money with legal fees doing it, and that may be the issue.
And so that's just one part of your problem. The other part's money. What do you do with it?
Yeah, I mean, it'll take. Yeah.
Done something to look at, or talk to the estate about quit claiming 76 and 37 and using those to build on and use the money from the sale of that to maintain lot 57?
That would be wonderful.
Well, has that been discussed? I mean,
No, it has
I'm just
not.
saying, what options have y'all looked at?
No, we haven't. All we've said is that we cannot accept that property. We have not talked to the estate about taking the money from the sale of the property at 37 and putting it into an escrow account for the maintenance of 57.
Well, I'm just throwing that,
Yeah.
where I'm coming from right now is that I don't feel like that you all done enough discussion with the estate to look at what are the options and to see what is there some common ground. Then you can come back to us and we have to have some involvement.
We can't fix the HOA issues, but
No,
what
and
we
we're
can
not
do,
asking you to.
right?
We're
But
not-
what we can do is help you try to work through what was approved in 1990, and if there is some quid pro quo that could occur here, we can help push that along. Now the estate may say nope, and that's my conclusion was exactly what Ed just said. If the estate wants to dispose of it, the estate could deed you guys all 3 lots. You could then sell lot 37. You would, in conjunction with the Planning Commission, have the authority to go through and revise the plat to make 37 buildable. Then you guys could use the proceeds, the homeowner association could use the proceeds as you see fit. Obviously, the estate would have to, be a player and agreeable to this. And this may be at a juncture where she can't even make that decision without talking to her client. But that was the conclusion when I read through this earlier this week, that I don't know how to solve this, but that was the only way that I could come up with, being that you have an albatross to work with going a lot of years back.
In our wildest dreams, when we were smoking, we were thinking it would be wonderful to have the money from 37 to put it in the escrow account. You remember that people bought units 4 and 5 thinking they were getting this $350,000 complex that was never delivered, and there was supposedly money put into it by homeowners. So as far as I'm concerned,
The option, you all can sue the estate.
well, we don't have the money.
Well,
Yeah.
we can't
Yeah,
fix
it's great.
that. I'm just saying what's
At a juncture,
theoretical.
you do have some leverage today. Now, if it all gets tied up in court with lawyers, and it's frustrating, but do you want to, do
Yeah,
you
I
have
think-
some
yeah.
thoughts about what you've discussed as far as disposal options with your client?
Well, yeah, go ahead, no.
Really, the only thing that I can say is our obligation is to, if there is a legal obligation for us to convey to the HOA, that's what we want to do. For Lot 37, there is no legal obligation. There's really even a question without covenants as to whether there's a legal subdivision that can be enforced with the common area. And that's the issue that I'm coming to with the other attorney for the other heir who's giving us problems, is he wouldn't even agree that there's a legal obligation to convey the common areas to the HOA, or, what exists as an HOA right now. I have advocated to him that it is our responsibility to convey those two properties. I can almost guarantee you that there is no way we can convey Lot 37, which is still on the books as a buildable lot, for no consideration. Our obligation is to take the assets of the state and maximize the value and then distribute them to the heirs and the creditors. So we can't give away what on the books is, I think, appraised as an $80,000 lot. I don't think it's worth that. But there is no way, we would be in a separate legal battle within the estate for trying to convey something that had value.
But don't you also have obligations to fulfill the liabilities of the estate?
Right now, we have nothing on paper that says that was an obligation. We have the minutes from this one MPC meeting. That's the first, when we got into this, and I called somebody from the HOA to say, hey, can we go ahead and deed this to you? It looks like we're supposed to be giving these lots to the HOA. That was the first that I had heard that there was an obligation to build recreational facilities. I mean, you're now dealing with the granddaughter of the original developer, and nobody knows anything. We don't know anything about $1,000 being paid per unit to build something. The paperwork is awful. And, normally when there's a plat and a subdivision and it's recorded, then we have the obligation, or the developer would have the obligation to convey the common areas. And that's what I'm trying to advocate for, is giving those over. But if they are now saying they don't want them, I don't know where that leaves us, except that we'll end up distributing them as part of the estate, and somebody else will fight the battle for us. Because in the end, we just have to get rid of them. If we have a legal obligation to convey them to the HOA and the HOA wants to accept them, then I think I can get through the hearings necessary for the probate estate and the battle with the other heir if that is the opinion of everybody involved in the room. But if that's not, and the HOA doesn't want them or can't afford to take them and now wants us to send them somewhere else, that's not what the plat says. It doesn't say give them to the town or give them to somebody else who can pay the taxes, because one of the heirs said, well, give them to me and I'll deal with it. What's the difference in giving them to one or the other if nobody has a legal obligation to take them? We're in a conundrum too, because our obligation is to get rid of them in accordance with the law, and now it looks like there's not a path to do that. So, the next issue would be, and I'd asked Mr. Shipley when I talked with him very early on, well, if there's, if the HOA doesn't want them, which is what we looked at kind of initially, does it have to be common area? Does it have to be green space? And his opinion is yes, and I'm happy to abide by that, but I can't guarantee that if we convey it to one of the heirs as a residuary property, that they're going to agree with it, and that there won't be an issue of, the plat was recorded in spite of the fact that the recreational facilities were not built. Does that waive the Planning Commission's ability to enforce that? There are no covenants requiring that these be common areas. Does that, preclude there being an action to enforce these as common areas rather than buildable lots? There are lots of legal issues that surround these two lots, and I'm trying to avoid getting into that kind of battle or passing it on to somebody else to be the next problem. What I want to do is convey them to the HOA. If the HOA doesn't want them or can't afford to pay them, then I would appreciate some guidance on what we do next with them, that I can pass through the probate estate and get through the rest of the heirs. So.
Well, I think the documents that I'm looking at, these are recorded plats, or one recorded plat at the Knox County Courthouse of public record. So I guess what I'm not understanding is how there's obligations that you're not seeing or your client's not seeing, whereas these have been a public record for many years. It's not like they've been hidden somewhere in a file cabinet.
The plat that is recorded does not have the notation about no building permits will be issued for Lot 37 until it's developed, is my recollection.
You're saying that was not on the recorded?
That is not on the recorded plat. And
so the
Mark,
document that's
correct
in
me
my
if I'm wrong.
packet, that is not an excerpt of the plat? Is that something else just...
It's copies that we keep copies here at the town hall. I don't know exactly what's on record at
Now
the registered
this
deeds,
looks
but
like,
it has all the
I've been around enough
signatures.
plats that this page right here actually looks like a plat. I can see all the certifications for street recording, and I can see a lot of plat notes. And matter of fact, I even have an instrument number from '98. Now, this one does not have an instrument number that has the language on it. It would be interesting to see, because to me, it's a real black and white situation. If this has been recorded, it's a public record. Those homeowners that moved into those neighborhoods.
Got a fee stamp in the lower right.
Well, I'm looking at the one on the left.
Right, the one on,
The-
the
the
one that
open
has the language
space-
that's prohibiting the building on lot 37 until the recreational facilities are finished was not recorded. Or I've not seen it of record. There is a plat of record, and I believe the language about the common area,
This one wasn't recorded, is what they're saying.
Yeah.
This one has been recorded,
Yeah, and it's also got that.
Now,
but this one hasn't.
this is it. I mean, this is a plat of record. I mean, there's the instrument number. This is recorded as public record at the
but
courthouse.
it doesn't have language about not building on lot 37.
Right. Well, the only thing.
It has to be used for recreational purposes. It doesn't require that it be conveyed to the HOA.
You're correct. You're correct. But you can't build houses on it. I mean, that's black and white. I mean, permanent open space, I don't think there's any ambiguity in that.
Open space is open.
Yeah, and that may be true, but somebody who looks at this and says that there's not a set of covenants for unit 4 and is looking at 4 acres of buildable property would probably take the chance with a legal battle. The estate doesn't want to. We don't want to pay any more attorney fees. I've earned more than my share with all kinds of other issues relating to this estate. We just want to get it to who it needs to go for. We don't want to, we're not trying to sell it, we're not trying to pass it off to somebody else who wants to build on it. We want to give it to whatever the form of the HOA is that's in existence. That's what we've been trying to do. the whole
When you're
time.
saying it, you're talking specifically about lots 57
57
and.
and 76.
But we are not talking about lot 37. Obviously, 37 is the only one that would have any value to be able to help compensate the HOA for promises that may or may not have been made.
Right, and I have no record.
If it's not on the plat, I can't go back. If it's whatever the plat says, is the only thing I can go back with. What I fear tonight is that Noah, as a planning commissioner, is going outside my bounds of jurisdiction, of where I'm not an attorney, and I can't interpret some of these things that you guys are dealing with. What I would encourage you to do, and I think I speak for the whole planning commission, the town staff, is try to come up with something amicable between both parties. I think there's. My instinct says there's going to have to be some compensation, whether it comes through the lot, that lot 37 or not, I don't know, to be able to try it. I don't think the HOA is going to be made whole, but I think if you can get the HOA somewhere between zero and whole, I think the HOA might be more willing to work and accept these other parcels, which are definitely deeded as per the plat as open space parcels. I mean, you got the big one, and then the detention pond.
If we can afford to pay for them, we would take it in 5 seconds. I mean, it's right smack in the middle of our neighborhood. Of course we want it. It's not a matter of not wanting it. It's that we can't, I don't know how we could afford to pay for it. We would have to double the homeowners' fees. And it's still,
Have less money.
yeah, we don't, I mean.
Well, I don't think we're not solving it tonight, and I don't think we have enough information. And quite frankly, I think this is so outside our area of expertise and our area of jurisdiction. We're just not going to solve this, and we're at some of an impasse. And
We are too. We've been in an impasse.
well, what I would hope is that there's some light at the end of the tunnel, and it's not a freight train, and you guys can be able to work through something that's fair and equitable. As much as can be made. Obviously, I don't think the HOA is going to get all their hopes and dreams fulfilled, but I think there's something that's fair and equitable. Otherwise, how I see this, the town still has the right to be able to withhold that building permit from here to perpetuity on lot 37, which renders your lot 37 somewhat worthless. And so, and that's really the only thing that this body has the ability to do. We can't get into your business with your HOA or lack of HOAs. But what we can do is exactly what is on this plat. Now, is there some ambiguity with what plat says what? The plats that I've seen, we're dealing with open space, and that's just going to have to go with the town attorney, and we're going to have to use his advice. And his advice is, we're going to stick to our guns on this, and that's just what it is. But unfortunately, we're not going to solve it tonight.
No,
I think we would, but we wanted you to start to be aware of the intricacies of the issue.
It's complicated.
I have a question which kind of frames the size of the problem.
Lived in Sugar.
is how many heirs are there in the
That was my question.
How many heirs in the estate? There are potentially, there are several bequests to churches and cemeteries and that sort of thing, but there are 3 granddaughters and 1 daughter. There are 2 versions of the will, as well as the risk that it passes according to intestacy, so we are in the middle of a will contest. One of the heirs is diametrically opposed to the 3 granddaughters. And that's the reason that I was hoping we had an agreement, that I thought we had an agreement, and that's why we were coming to kind of get an early blessing, because with everybody on the same page, I felt like we could push this through the court to get the court order to send these properties to the HOA and get them off of the estate's books. If that's not the case, I can guarantee we will not get approval from the other heir to convey Lot 37, which has value, maybe nominal value if it can't be built on, but it has value in the eyes of the other heir. And she's not going to consent to it being conveyed. I would have a hard time. She would not consent to the other 2 being conveyed, but I think I can win that battle in court to get those back to the HOA based on the plat. But she would fight the opposite side of that battle on Lot 37, and I don't think there's enough evidence for me to convince her, for even her attorney to convince her otherwise. And I couldn't recommend conveying that lot to somebody when it appears to have value for the estate for 37. I think there's a question as to whether the planning commission could enforce a no-build permit as well against a third-party purchaser. If your intent was to punish the original developer who's dead, I don't know whether there would be a legal challenge on that basis either. And that's not what I want to do, and I wouldn't do it. It would just be whoever the property gets conveyed to that would be dealing with that down the road. I would like to be able to tie this up so that we don't have future legal issues in that subdivision, even for the next purchaser, because I don't think that benefits anybody to keep just passing this problem on to the next round of owners.
So, again, we have very little that we can do with this. And we realize you all want us to know what's going on, and we do, but at this point, we really have nothing that we can do.
I've got a couple other people that have signed up.
Okay.
If they want to say anything.
If they have anything additional
Yeah.
to add to this, but at this point, we really can't.
Marshall Lehman, are you Marshall?
Marshall Lehman, 11423 Bancroft Lane, which is in Unit 5 of Sweet Briar. I am the original homeowner, purchased in the summer of '99. My comments are really, one, echoing comments that Carol made, that yes, a Unit 5 HOA was, I even hesitate to say created, I'll say registered in early '98. As I say, I bought the home from the builder in the summer of '99, and by December of '99, that HOA was administratively dissolved because nothing was ever done with it. The only homeowner dues I have ever paid have been to the voluntary HOA, which covers every home in Sweet Briar, whether it's 1, 2, 3, 4, or 5. So I guess I would like the report to the Farragut Municipal Planning Commission under the discussion paragraph says only Unit 5 has a homeowners association. That sounds like we currently have one, and we do not.
Yeah, that needed to be changed. You could say had.
No, it never had. There were never officers, there were never dues, nothing was ever collected. So as a person who purchased in '99 and was never assessed, never met an officer, even when you look at the original registration, the only name on it was McSpadden. There were no other officers or board. So in my mind, the name was registered, and that's where it ended. There's been no Unit 5 HOA.
Okay, thank you. We'll,
So that's my comment. I just want that clear. There is no Unit 5 HOA. You can find.
Knapp had signed up too. I don't know if you had any comments.
You're passing.
Okay.
Can I make one clarification, which I forgot to do at the beginning, to Mark? Excellent. Trying to herd cats here. Under discussion of the report that he sent you all. Oh, am I recognized?
go ahead.
I'm sorry.
That's okay.
Under discussion, it's on towards the second half, where it says only Unit 5 has a homeowner. It should say had, and she did not, and she clarified There never was one. The last sentence is also not correct. There are also no apparent covenants that address the ownership and maintenance of the open space lots in Sweet Briar. That is also not the case. It is in Article 4 of the covenants for Unit 5 that say, subject to the provision in Section 3 hereunder, every member of Unit 5 will have an easement of enjoyment in and to common properties, and such easement shall be appurtenant to and shall pass with the title to every lot. Second paragraph, owners of lots in Sweet Briar Subdivision 1, 2, 3, and 4 shall have a right and easement of enjoyment to the common properties, subject to the provisions of Section 3 below. I'll just read it, sorry. Owners of lots in Unit 1, 2, and 3 must pay an initial fee of $325 for the right to use the common properties. Any owner in said units who wishes to use the common properties prior to January 2003 shall pay an initiation fee to the association, Unit 5 Association, which shall then forward said payments to the developer. Owners of I'm skipping one, it's irrelevant. Owners of lots in Units 1, 2, 3, and 4 shall not be members of the Sweet Briar Subdivision Unit 5 Homeowners Association. So the full responsibility for the open space is to Unit 5. Now,
But Unit 5 doesn't have,
that's correct.
so the only language for
That's
open
correct.
space is in a document that has no standing, because it doesn't
That's right.
exist?
You all approved this. The town of Farragut approved this garbage.
We don't get involved, that was before
Well,
we got
who
involved
does?
with covenants. We didn't get involved with covenants back then.
Developer write them up, whoever's first,
Well,
and it gets
nobody
registered, and it
looks
gets
at these
registered
things?
with the
We
county.
do now.
Yeah.
We do now, we didn't then.
Well, this is 1996.
Right, yeah.
We didn't.
Again, let me put
Reason
you,
we do now.
I don't
Yeah.
want to take any more of your
well,
time.
let
I
me put you
understand.
in
Oh, it is,
contact
yeah.
with the person in my neighborhood, because we've had a very similar process.
Right, yeah. Okay,
And
that's great.
they can talk, I'm sure I'll ask them to talk to you, let's put it that way.
Okay.
And see, because they have, to a certain extent, straightened a few things out.
Okay, great. Thank you so
It has
much.
nothing to do with the planning commission.
Thank you.
Okay, that was for discussion purposes only, and I think we did.
Jack lives in Sweet Briar.
No.
Well, you do too.
On now. We will move on now to discussion on the site plan number 7 for Kingston Pike Villages, parcel 78.03, 79, 80, 81, tax map 151, 13110 Kingston Pike, west intersection of South Watt Road and Kingston Pike. 18.59 acres, zone PCD, planned commercial development, GBS engineering applicant. And also, this is for discussion purposes only.
Yeah, this is. Well, as you all know, we had a workshop discussion on this back in December. I wasn't at the meeting, but there were a number of issues that were discussed. Staff has still pending a lot of comments on the site plan, which is understandable. It's a very large, complex development. And I think what the applicant would like to do tonight is just keep this real focused, and they presented a couple of things from the design that they just want to get some additional guidance from the Planning Commission on, so that they can move forward with addressing some of the other comments from the staff's review. One of the comments that we talked about in December was the shared access point and some internal traffic circulation with and between the project site and Little Joe's Pizza, corner of South Watt Road and Kingston Pike. And as a follow-up on that particular item, as part of this workshop discussion, the applicant's engineer has submitted what's shown there on the screen as as an option. As you all know, the staff has a concern with the access there for Little Joe's there. It's west of their facility. It's about 130 feet from South Watt Road intersection. Obviously, that's a non-compliant existing situation. The concern was that tying it into this development, which is a good thing, does add a lot more potential traffic to that non-compliant location for the access. So what they're showing here, that's on the screen, to try to address this, and apparently it was discussed somewhat at the Planning Commission meeting, is a right in, right out, and with an access point that's tied in to the Little Joe's property in the kind of the south part of the lot, which is a good location for that. Couple of things. This does appear to address some of the comments that were apparently raised at the meeting. I think there's a couple of things that the town engineer has recommended that need to be, tweaked on this. Go ahead and maybe the intent was to do this anyway. Go ahead and extend the curb and gutter, along that section, and then that would allow this to be brought down kind of in line with the curb and gutter and make that more pronounced so as to further discourage an inappropriate turning movement into that particular access point. Let's see here. And then another thing, just to try to revisit, is to try to get some pedestrian connection between the two. It's good to have the vehicular connection, but also figure out how we can get a pedestrian connection, because we want them to be interconnected, both in terms of a vehicular connection and pedestrian connections. So try to figure that out, maybe get some kind of connection, extend this or something. That'll need to be something that would be tweaked with the revision. So I guess we'll just talk about these at one time. So does anybody have any questions on this particular aspect? Or Mark, you might have some comments on what I mentioned, but that was the staff's opinion on this particular, just make those adjustments.
Mark Bialik, GBS Engineering, 1313 Cameo Road. I think I've been in front of y'all. Y'all know who I am pretty much. The curb and gutter, there's an existing curb inlet right there that is curb and gutter right now. It just doesn't show the gutter pan in the survey information that was given.
To just extend, just show that then.
It's already curb and gutter through there. And correct me if I'm wrong, Travis, am I wrong on that?
A portion of it is, Mark, it's about halfway down to the sign, which is about the middle of the building.
Okay.
If I'm not mistaken, I think that's going to be addressed with the Kingston
Pike modifications.
Whenever that gets redone.
Yep.
I think they're going to put in sidewalk and curb and gutter all along the frontage of the little bit of property.
Yeah, and I can't.
Okay.
I can. What you see there, I provided to Travis and Laura, and got their blessing, for the most part, before we submitted this to the town. So they didn't have any. They had one comment, and because they do have a door on the west side of their building.
Yeah.
And we shifted the entrance over about 6 feet to make sure that when that door opens, you'll have no problems with people walking in and out. Okay. Is that an emergency egress door? Is that an emergency egress door, or is that a delivery door?
It's both. It's considered emergency egress.
So, I mean, we did shift the drive towards us to make sure that there was at least 6 foot clear from the building to the back of curb. We did create, by putting curb and gutter in on their property, did create 4 additional parking spaces that are not there right now. And all it would, I think I can speak for the developer. I don't think we'd have heartburn about putting a little curb in and just saw cutting some asphalt out to do that for Little Joe's.
Mark Shipley, would you identify the 4 parking spots he's talking about?
The ones right behind.
That's kind of what I figured, but it looks like that are kind of right up to the property line.
Yes.
Talk about these.
Yes,
Okay.
those spaces right
Those are
there.
those are new spaces.
Yeah, there's now spaces there right now.
Okay.
What is that space at the end of the middle parking island?
Crosshatch.
With the
That cross-hatching is it's a fire lane. It didn't say it, but I mean, I remember because when I was out there walking around with Travis and Daryl Smith and Alan Childers, and we do have Alan Childers working on a traffic study for us right now. He's finished all the counts. I'm expecting a report hopefully within the next week, at least a draft.
What, the speckled area is the dumpster?
The speckled area is the dumpster, yes.
Okay.
And I know that one of the things that Travis and Laura asked is potential maybe getting a curb cut to access the property behind the dumpster area for employee parking. We'll work with them on that. And in regards to grades, I've got a 4% grade going down into their property. It's real flat. The grades are not an issue. The reason I have that, Mark, the reason I have that island on an angle is because it follows the taper for the decel lane for the right turn.
The decel lane looks real short. Is there an obstacle out there in the field that's causing such a short decel lane?
It's not no, we're putting a taper to the decel lane for the right turn onto South Watt Road.
Well,
that's the existing lane that's
Well,
there.
the taper that it looks like to me looks like that's actually in the outside eastbound lane of Kingston
Actually,
Pike.
that's about a 75-foot taper for about a 100-foot lane.
Okay.
I've got a 40-foot radius on there with the 40.
Okay.
Make-
That's
to
what's
make-
throwing me
to
off.
make
I
the
didn't realize
island, so the object of this is to make the island big enough so that it deters people.
It's a
trying to
lot
make
bigger
left
than
turn.
most right-in, right-outs.
Oh, it's, yes.
Okay.
This is
It's more almost
I
like
follow
little slip
state
ramps.
guidelines. I follow TDOT guidelines on this.
Okay.
Pardon it?
I was just saying, if you look at the size of the island relative to the size of the building, it's big.
Yeah.
Defer to the town engineer on that, but I think the bottom line is he's just wanting to make it very uninviting to try to make an inappropriate turn there. That's basically the bottom line.
Yeah, and I agree with him. We don't want people trying to make a left turn into there.
Yep.
Well, if somebody parks over at the retail shops and they're going to walk over to Little Joe's,
You'll be walking like you're walking across the parking lot out here.
okay, so
There's no big slope or anything.
Well, I guess I'm just thinking, would it make sense between that curb line and the Little Joe's where what we're talking about, this delivery door fire exit is? Would it make sense to have some sort of a sidewalk there? If you're going to have a 8-inch extruded curb, you don't want to step over the curb, and now you got a hole over there holding water.
Well, that's their property.
Well, I realize this, but we're trying to. One of the things that we'd like to do is have interconnectivity for your pedestrians.
I
And so, if
agree.
there's somebody shopping over there, and they want to go eat over at Little Joe's. I know where the Little Joe's front door is, and they're going to go the path of least resistance. So they're going to walk kind of down this right in, right out area, and try to get on that sidewalk. It'd just be handy while y'all were doing it.
We can put a sidewalk on our side of the property.
Well, you got the property line going right down the middle of it.
No,
It wouldn't make
between
sense for
us and
Travis
the
to pour a half of it, and you try to do half of it. It's never going to look right.
Well, no, I was going to say we could put a sidewalk between the retail shops and the right in, right out.
Now, where are you proposing what would be a good spot to try? And I think this would
coming
address
right-
one of the next items in our agenda is to talk about the pedestrian connectivity between these two parcels.
Well, there's only 6 foot between the back of curb and their building,
Okay.
which right now there's nothing.
It's just asphalt.
It's asphalt right up
Right.
to their building.
Right. And
So-
grading wise, you may not have, it may be difficult to get a couple inches of stone and 4 inches of concrete in there.
I'd put it this way.
Unless you're going to drop the whole elevation.
Unless Travis and Laura are willing to absolve us from any liability of putting a sidewalk against their building, I wouldn't recommend my developer do it.
Travis, if we'd want to get you on the record, but if you'd want to come up and just have your thoughts, because we've got to address this pedestrian connection between the two properties, and this is the great time to do it. I think it behooves both property owners. I think you're going to have customers that you're going to share. It's going to be good for business for both, and so. But I think this is the time to try to, if there's a solution, and maybe it's like the previous agenda item. There's just not a solution to it. But it seems to me that there's just not an easy way. If your customers are parked over there and they want to go over to the retail shops and I don't know, grab a Hallmark card or vice versa. Have you guys have any thoughts of how to do this? We need you at the microphone,
We need
Travis.
you to come up to the microphone, please. And if you would, tell us who you are and give an address.
Sure. Travis Presley with Little Joe's Pizza, 13100 Kingston Pike. The last I saw of the drawing, the curb and gutter, or the extruded curb on the eastern side of that right in, right out was a lot closer to the building. And I guess, Mark, since...
We moved it 6 feet off.
Okay, and that was our recommendation, and my thoughts were if we could move that curb or the extruded curb over a certain amount, leave some of the existing asphalt up against the building, then have a sidewalk and then a 3-foot grass strip before the extruded curb. I thought that might be a good way to go, but if you're talking...
We don't have enough room. We got enough green space between us and the retail shops and the building.
Yeah, those were my thoughts, were to try to put in pedestrian access along the side of the building, not pour the sidewalk up against the building, but give yourself a good couple, 2 or 3 feet, so that you're not trying to construct the sidewalk right up against the building. Those were my only thoughts.
What I don't want to, we don't want to see a sidewalk down in a hole there, back behind an 8-inch extruded curb up against your building.
Right.
But I think there's just, it seems like we're so close to being able to connect the dots here, but we're just not quite there. And it seems like there should be a really easy way to have just a little bit better pedestrian connection between these two buildings.
I agree.
I mean, Travis, are you opposed just to having a 6-foot sidewalk between the back of curb and your building?
No, we were thinking some sort of pedestrian access, in particular now that we're going to lose the parking on the west side, and it's going to shift even more of the parking to the rear. Right now, the existing, you see the majority of the parking is on the east side, and so people come in from that direction to the front. So if we're going to have more parking in the rear, we would need some sort of pedestrian facilities, I think, to go in on the west side.
Well, it seems like if you had a sidewalk that connected I'm going to call your front door sidewalk, closest to Kingston Pike, where your current front door is, that just went along their curb line, and at a minimum stopped where their sidewalk is on the south side of their retail shops.
Yes.
I mean, it seems like that's going to, it may not directly connect over to your property, but, maybe you could go in and pour a couple of yards of concrete and have a little connection to the sidewalk. But it seems like we're so close to getting something that makes good sense with a pre-existing building and something new and that's good for both of you. But ultimately, they're tenants and Little Joe's.
Right, that's exactly what I was thinking was, like I said, a sidewalk along the western side of the new curb line, and I was thinking they would probably go a little further down than their sidewalk, but now that I see that, maybe a crosswalk there, a sidewalk and a crosswalk, those seem like a logical thing to do.
Are you talking about something along here?
Correct.
That's exactly what I'm talking about.
Yes, sir. And initially I thought it would go on back, the sidewalk would go to the end of the curb, Mark, like further south, but now that, I guess now that you're make the point that the sidewalk, it's a good location.
Well, it'd be probably a safer crossing as you further out of that access point.
Yeah.
Right. You get away from those turning movements.
Yeah, get out of that because somebody could be coming in there eastbound on 2 wheels if they're not careful.
And Mark, you could turn that into a T. Travis could pour the concrete, basically, do the other top of the T over to where his turnaround area is, and that's going to solve a lot of issues with customers, overflow parking, and employees parking back there coming around the building. I mean, now you have 2 routes around the front, and I think you've solved the pedestrian connection issues.
That's what I envisioned.
We'll agree to put the stripe zone for going through there.
For like the little crosswalk?
The crosswalk,
Put
yes.
some stripes in there for hashing?
Yep. We'll do this thermoplastic striping, proper thermoplastic price back there. But building the sidewalk against the building, I can't recommend that for my developer.
What we can do, though, is we could give
your name.
Daniel Smith, 810 Henley Street, Knoxville, Tennessee, 37902, representing the developer. What we probably could do on this, and I'll talk to Tyler about it when I get done with this meeting, but I think what we could do is grant a access easement there on our property line to allow for them to have pedestrian access and be able to put in their own sidewalk. Because that's the thing, the problem is that the property line goes right through there, so.
I agree.
He does have an access easement already though through there. Does it provide pedestrian? So really he just needs some sort of construction easement that you can go on there and pour a sidewalk, and what we'll do is we'll take the sidewalk over and set it up for that in terms of the hashing. And you could probably put it in the plat.
I mean, to me, it looks like that sidewalk diagonally goes through it at about a 50-50 rate. I don't know if you guys can come up with something that's fair and equitable. But it looks like half of it's going to be on you, Daniel, and half of it's going to be on Travis. You got to come up with a solution. I mean, obviously, somebody's got to pay for the concrete. Somebody's got to pay for the guy to go out there and finish it. But and I don't know if you guys can solve this. I'm good at creating issues and making other people go away and solve it.
We're
but
going to have to put in a curb.
Yeah, we're actually, that's not an extruded curb, that's a curb and gutter.
Well, I think what you also need to keep in mind is the grade of your curb needs to be such that if he does install a sidewalk, because you may have to lower your elevation of that area a little bit. So if he does have a sidewalk, when it rains, it doesn't flow into his building. It flows away from his building. It only takes, you could probably do that with a 1/4 inch, a foot of fall.
Yeah,
but I think there needs to be some coordination.
We'll work with that on that. That's not a problem.
So we can.
We're matching existing grades out there.
Well, I'm saying your existing grade right now, my instinct is your existing grade is going to be a little too high. But based on what I know being around, I mean, I can't tell you the last time I was on that side of that building, but based on what I know about the asphalt, you probably have to strip some up and lower the elevation down a little bit, because right now that asphalt's pretty much flush with the threshold of his door.
That's fairly accurate.
We're going to have to cut that all up anyways and remove that when we do everything that we're going to do, so we'll make sure the grade is fine such that there's enough.
I can't create a flooding problem.
Right.
That's understood.
Well, I mean, do you think there's also a way, I can understand that you have some apprehension about, going through and with a mini excavator stripping up asphalt right next to somebody's building footers and their foundation and liability, but surely there was a way that you guys could work through this to be able to kind of solve this sidewalk issue, because it doesn't make sense to have two different subcontractors out there pouring on the same sidewalk.
I understand. Yeah, we'll work. As long as Travis and Laura are willing to work, we'll work with them.
Absolutely. Were you thinking of a different location, Daniel, on the sidewalk?
I think that eligible.
Gentlemen, we need you at the microphone. I'm sorry to do this to you, but we've got folks at home that are trying to watch it, and it's on record with YouTube, and if anybody wants to come back and listen to what you have to say, everybody needs to hear it.
Right. I was just making sure that we are under the same understanding that the sidewalk as shown in yellow is what you had in mind. I think that was what we initially had in mind. I thought that there might be some room to move that over a little further to the west, so that we didn't have to pour the sidewalk directly adjacent to the building. But if the room is not there, I'm sure we can accommodate that. But that was our initial game plan, was the pedestrian facilities as shown in yellow.
Being the top of the T is just a hashed area with a crosswalk. It's already existing asphalt. You're just going to delineate it as a crosswalk. I think what you guys got to solve is...
Actually, we're putting all new asphalt right there.
Well, yeah, I mean, obviously it's old asphalt. I figured you wouldn't be using the old asphalt. But again, it's
We're going
not...
to build a whole new entrance into the property.
Right.
I mean, all the asphalt that's there is, it's worked for 20-plus years, but it's time to upgrade and get something that's consistent with everything else.
Do you think you guys can, we're discussing tonight, but next time I think Daniel would like to have this as an action item. Do you think y'all can agree on whatever if there's a cost share, there's a cost share, but we need to see it on the plans.
Understood. We'll talk about it and see if we can get to an agreement. I think it's not, it's only, what is that, 50 feet? 50 times 5 times whatever. We can talk about it.
Okay.
I feel like it's something that we can come to an agreement on, yes.
All right. Now, do we want to jump into open space, Mark and Madam Chairman?
Yeah, the other item they wanted some guidance on was open space, and then they submitted, I think we talked about this apparently back in December as well, and I think the commission knows the staff's opinion on the open space for this development. It's been well stated. And they've got two options that they're presenting. And the first one is basically what was on the original plan, and that is that it basically would be at the grade and this is the western open space, not the one near Watt Road. The first option would be basically at grade with the shopping center. As you all know, when we got in and the site plan and more detailed information, we see that there's a pretty good grade separation there. You're going to have a retaining wall, regardless of how you address this, of somewhere between 13 to 17 feet. So that's one option. Basically, the apartment would be elevated above
But
the
with
open
this option,
space.
Mark, but with this option, we've also added at Louise's request, what it would look like to get pedestrian access down from the apartments closest on the west side of the property. We added a set of steps.
That's over. Okay.
And a set of sidewalk that goes over to that area.
Okay. The second option was to actually fill that area and bring the open space up to grade with the apartment development. The apartment dwelling units, they're probably the ones that are going to try to use this open space, I would imagine. And from a staff's perspective, based on the two options, our preference would be option 2. We think it's a little more usable for the people that would be living in the apartment because it's at grade with them. It would still obviously need to be connected, and it is shown to be connected down to the shopping center. When we looked at this open space as part of the concept plan, there's a lot of things that's changed since we've gotten into the site plan from what was approved on the concept plan. There's a connection that was shown, some things with...
Which I said at the time that was probably going to go away because of grades.
Right. But this open space was kind of shown as something it really has not become because of the grade separation. It's really not a integration element within the development. I think at this point we're just trying to make the best of, in my opinion, a bad situation. I think having it elevated to the level of the apartments is a preferred option as opposed to the other option, because it is up there to where it would be more likely to be used by people that are going to be more likely to use it, I would imagine, than people that are shopping at the grocery store. So that's this particular open space. Of course, there's still the question about the open space along Watt Road that I guess Mark's still working on.
Yes.
Because a lot of that, as you all may recall from December, is very different from what's on the concept plan as well. It's a lot of grading and space devoted to stormwater detention as opposed to what was shown on the concept plan. It was a more functional and usable gathering space. So as far as the other open space, I think they would like to have some guidance about whether you all would prefer option 1 or 2. Mark can talk about any other questions that you all may have.
Any questions you may have?
I've got an idea about the open space with I'm going to call it the kind of the gazebo, the first open space we're talking about. In my experience with retaining walls, a 10-foot tall wall is about a third of the price of a 20-foot wall. And I'm trying to lead you to the trough and see if you'll drink. What about splitting the difference? And that way you have a terrace in there that is about half. So it's somewhat reasonably inviting for somebody down below. You had mentioned something about maybe projecting up some movies on a stone wall or on the retaining wall and doing something interesting like that. And then also have it where you have some steps.
No, I'm going to stop you right there because then you're cutting the open space into 2 areas.
No, I'm not. Nope. I would still be the same. I'm not talking about split the difference of I'm talking about horizontally splitting the difference. And so instead of having one large retaining wall down either at the bottom, I'll call it the north side of the open space, or a large retaining wall up at the south side of the open space, which is kind of options 1 and 2, 2 smaller retaining walls, the square footage of the open space stays the exact same. And you're also dealing with half the height retaining walls. And again, my experience, half the height of the retaining wall is a third of the cost.
But when it goes, But when it goes around by the apartments, it's still going to be one wall. I can't get two walls.
Well, yeah,
in there.
eventually you're going to have to connect it. You're going to have to connect it over on this side.
Yes.
But what my thought is, instead of whatever, let's just say that right now we're either dealing with an elevation of, let's say we got option 1, which is kind of the original plan. We'll say it's at elevation 1,000 feet. And then option 2 is at elevation 1,020. I'm talking about putting it 1,010. So all of a sudden you've got a terrace in there where you've got 2 shorter retaining walls. Again, you guys got to embrace it. I think it would save you money, but and I also think you would have something where from the apartments you would step down half the number of steps, and from the grocery store you'd step up half the number of steps on either a worst case scenario that the other options A or B.
I'm open to that. If you all are agreed to it, I'll be more
Now,
than happy.
there may be other ramifications that I haven't thought about. There may be some utilities in there I'm not aware of.
It was actually something I mentioned the last time we were here. I think what you were trying to do is keep that area flat. But that's
keeps it flat. You can figure out how whatever drainage system you're going to use, you can still maintain that same drainage system, which is going to be some internal drainage system. Anytime you're above a retaining wall, you've got to have some drainage and deal with hydrostatic pressure and so forth. But my thought is, all of a sudden, I think it's kind of cool to have this little terrace, this little bench up there, which is still going to be this big area. And it's not as intimidating as walking up all those steps, or as intimidating for walking all down those steps for the apartment folks.
It's just a grading exercise to me, so I can live with that.
I've been thinking about this for a while.
Okay.
The reason we're at this point is because of Louise's comment.
Blame it on Louise.
I'm sorry. And I've learned that once we got to the grading and the topography, I mean, it's one thing to say we're going to have topography issues, okay. But once you see it and you start realizing, okay, how are we making this a place someone wants to live? That's my comment from last week.
Yes.
The most important thing to me is that and maybe the rest of the commission disagrees, is we need to make sure that this is a place people want to live, because
we want them to too, because otherwise they're not going to move in.
Yes. Have you guys figured out what the height of your retaining walls and the rear of the property? Have you figured that out yet?
Actually, in the spot that we were talking last time we were here, I have been out there and walked that area. That one corner, we can grade that down because it's wide open. There's no trees in the area that have any impact. We can grade it down, lower the height in that one corner.
You talking about the northwest corner?
The southwest corner.
Or southwest corner, okay.
The southwest corner.
Stay with me for a minute.
Yes, I'm with it.
What's the height that you're thinking?
I think I can take at least 6 feet off the top of it,
So you're
which would be
thinking it'll
down
probably
from 31 down to 25.
Okay. So 25 feet is what, 1 2/3 of 2 stories of?
Basically, yes.
We call it 2-story 10 feet, which is kind of average.
Yeah, you're talking about 2.5 stories, yes.
2.5 stories. It's a significantly tall retaining wall.
This is what I've been thinking about, because one of the goals, and I'm just go with me and give it
I'm
thought.
waiting for you to finish.
It talks about encouraging efficient use of land. These apartment buildings on this end are 3 stories.
Yes.
Can we consider a 4th story on these apartment buildings? Because even when you raise it up, it's still not, the residential around it is still going to be higher.
Oh, yes, much higher.
4th story. And that to me is what what we were looking at when you're thinking about making sure that you're not negatively impacting the residential, is having this tall building and then having a house like this. You're still going to be below where.
You're talking about the houses on Old Stage, Louise? What houses are you talking about?
No, she's talking about the houses
on Old Stage or on
Shipley.
That little Shipley
Lane. So this would be like 4-3 splits?
No.
There's the zoning is the problem. Because
does PCD even allow us to do that?
Ordinance change, yes.
That's the only
But go
problem.
with me. I don't know how many apartments are in this building right at the circle when you enter in.
The first building that's parallel with the grocery store parking?
Yes.
That's 26.
So is there a way to compensate there by making a few of these buildings that are going to be below grade of, I don't know, I'm not using the right language.
No, you're saying
Can we
right.
add a 4th story? Think about where we could add a 4th story where it's not going to be visually bad for the residents around it.
You're worried about somebody looking out their balcony, looking outside the grocery store?
No. I'm
She's worried
thinking
about-
that if we
I'm not
remove
following.
that building and make that green space, then whatever green space we've lost at the drainage, then you're not trying to cram as much green space there. You've got this whole big strip of usable green space for the apartments. It's something that looks very beautiful from their perspective. It's a very attractive buffer between the apartments and a parking lot. And it's a big usable space. You could potentially section some of that off.
There's a few things to think about. The first thing, there is a cost component for going to 4 stories.
Okay.
Second thing is you're talking it being a rough situation without having elevators. And so those two things take a 4-story walk up and make it more challenging for that reason.
That was my wonder.
When you do the 3-4 splits, most of the people that are in the 4th floor are parking on the top
Third.
half of the split. And so
Okay.
that is the one thing that would make it a detracting thing for this community. And the cost of going to an elevator is extreme. So that's the play with that.
They have to have an elevator on a 3-story. I don't know.
As long as but no, if you provide ADA apartments on the main,
Yeah, we don't have to.
Yeah.
I'm going based on what we're doing at Overlook, and we don't have elevators in that.
Yeah, that's not my
And-
expertise.
I know that the plans are now in front of Dan and John in regards to the building, so.
What she's saying is, again, trying to make something that's marketable. When I look at that first apartment building, I question who would want to live there.
can you circle the building you're talking about, Mark, when you say
Because
first?
It's right there at the entrance. You got all the headlights coming in. It overlooks a large grocery store parking lot and loading area fairly close by. To me, I don't see it as a marketable property. I mean, I guess people will eventually live there, but I think what we're trying to do is come up with something that would be of benefit to the developer as well.
Yeah, when
Something that gives, more marketability there, and having that larger open space, and then having the buildings more, I guess, shielded from what could be seen by many people that would want to live there as unfavorable aspects.
Louise, I'm missing something here. How does a taller building make that more marketable?
I'm not saying that it does, although you're looking at 2 stories of, the back of 2 stories, and I know it's not that
3
many
stories on the
apartments,
grocery store side.
well, these back buildings here on the south, is it
It's
south?
southwest side, the southwest, the ones that went parallel to the
The
western
first 2
property.
stories are looking into a retaining wall.
She's talking about getting rid of that building I circled and making all that a big open space.
Oh, that's ultimately what you're, okay.
Yes, yeah.
talking about.
Transfer that space to the.
Because, again, it's questionable as whether that building in that location is, I mean, I don't know.
That
It
building
just-
will rent, because it's mostly 1-bedroom apartments.
Yeah, I'm not sure how it's our job as a planning commission to be economists and determine.
Right, I understand that.
We want you to be successful. Now, what we don't
Yeah.
want is we don't want a vacant, dilapidated apartment complex. So we do have a responsibility there. But
Yeah,
I'd
no,
have a
I'm-
hard time telling you, what you can and can't do based upon your own market research on what you think is marketable, because I don't think you'd be spending the money there if you didn't think you could lease those units.
Yes.
I'm just this is more to kind of capture that, the green space that really, yeah, I'm not sure. I guess that's, because we're losing a lot of this, it sounds like it got bigger.
That's what I like
here.
about splitting the difference on the green space, because one of our objectives as far as the land use plan is when we take mixed style uses, what we're trying to do is we're trying to bring folks from both style of uses and bring them into a green space that they can share. And that's the whole idea, it's quote unquote, is to create a sense of community. And so if you're putting this green space way up, 20 feet up in the air, which is probably going to be like 30 risers, or maybe even probably 32 or 33 risers. And so that's going to make it so difficult to be able to climb up there, or you're making it down 30 risers for the apartment folks. It seems like if you split the difference, you're addressing that whole issue about creating a common meeting area for folks, or if there is an event there, folks can park down below and walk up to the green space. And
Well, would that matter whether the green space was that big or the size that it is now?
well, I mean, I guess there would be, something that you could host there that maybe you couldn't host if it was that size, but I don't think they really envisioned having that sort of a big of an event. I mean, is your event's going to be 50 people or 500 people? I don't know.
If I could make one point about that, I think there is a lot of merit. While I understand that the idea is that you want to make a functional space primarily for the residents, I think that the vast majority of the people that are coming to this property, there's going to be an impression of it that you want to be careful about having too much of a retaining wall right there at that grocery store. For the community, for the whole feel of the whole development, I think trying to figure out a way to soften it is, in my opinion, the better route to make it a more coherent, better place in terms of a sense of it being nice. And if you can do it, you can, like I've mentioned before, the property over on Paper Mill with the hotel, they have a lot of different retaining walls there that are done in a really nice way. And I think that it has a great feel to it. And I think that your idea is worth exploring. And I think we have some concern with the grocery store too, and having a massive retaining wall that close to the store, and the kind of impression that might give to shoppers might be detracting things. So I understand the staff's position on it, but I think that there is enough open space and common area for the community that they'll get use of it, and enough use of the common area, and to where that doesn't have to all go to them. That makes sense.
A girl can always dream.
Nothing wrong with dreaming.
Is there a possibility of, and I don't know how this is moving on to more open green space. We have all of the wooded area behind. Is there a way to put in just like a mulch trail, a linear mulch trail? Is
Well,
that?
If you remember, we are, as part of our agreement for the land swap between the property that our developer owns in the adjacent property yard, we have to put in a path up to the middle of that, and I have put in a set of steps. I've shown it now on my plan. I did not put it in front of you all because that's something we have to do as part of our agreement with the landowners, and it'll be a tenuous set of steps up there, because when I walked, like I told you all the last time I was here, I was going to go walk the southern property line, find out where we could grade to minimize retaining walls. Well, from South Watt Road over to about where you show that, like the double lines going towards the top of the page, that is all really heavily forested. And there's lots of undergrowth and everything in there. But from that double line going west, that's all been mowed and maintained. There's there's a couple of trees in there which we have to preserve, but there is nothing in there that says that we shouldn't be able to grade that at a 4-to-1 and knock down the height of the retaining wall in that area where we can. But I agree with what Mark was saying, is you can't, that land has been sitting there for however many years. You can't create a better buffer than what nature creates. So we don't want to disturb from basically that double line going to the top of the page, going towards South Watt Road, any more than we have to. Okay. And in fact, I'm actually looking into the similar type retaining wall that they did for the Pure Magic over here, because the tiebacks on that are non-existent, up to about 25 to 30 feet. So basically the wall will be, it may be 4 or 6 foot deep, but that's all the farther we have to go in.
So you don't have to overcut to build
We don't have to
wall.
overcut to build this retaining wall.
Right. It allows you to save trees.
Yes, to leave Mother Nature as it is as much as we can in that area.
So if anyone's going to walk through there, they're just
They'll
they'll develop their own.
Yes.
path
Well,
for
the other
walking.
thing is and walking that southern property line, I called the developer up and said, do you realize our surveyor didn't pick up all the fences that are up here?
Oh, jeez.
I had to jump over one 8-foot tall chain link fence. Thank God there was a tree across it so I could walk up a tree and jump over. And then there's, in that area over there, there's 3 strands of barbed wire on top of a 4-foot wire fence. So yeah, my employee and I had a nice exercise day that day because we were going to walk down the western property line, but as soon as you get down to about the bottom of that first building that runs parallel with the western property line, there's briars taller than me. And I said, I'm not dressed for this. So we walked our way back up and then over to Shipley Lane and walked all the way down and around because we parked where the old house was to start the thing. So we got about a 2-mile walk in that day.
And what you're doing there, that area that you're talking about back there on the southwest corner of Grocery Store, you're just going to plat an easement for future connectivity. That's how we kind of address.
We could do.
Isn't that how we address the vehicular connectivity issue?
No, you're not going to be able to get a vehicular.
Well, no, I know we can't, but I'm saying, but you're going to just plat something.
Well, no. What actually I'm proposing is, like we talked about initially, is at the southern end by the loading dock area, going into the mini storage. We'll plat in a 50-foot easement for future cross connection.
Okay.
We have no problems with that. But I'll tell you right now.
Probably never
you know what the
used.
number one landowner in the United States is? And it's not the U.S. government. Mini storage. Have you ever seen one go out of business?
Let's talk about your,
I've
the
never
other,
seen one go out of business.
Mark,
so.
let's talk about the other open space and detention pond. That's something that's also that we need to address tonight.
No, I'm actually doing the drainage calculations right now to put in more hybrid systems
It's filled with crap.
to minimize, and that pond is going to be basically for the apartments. And if I can shrink it, I will shrink that pond down as small as I can make it.
I'm not pushing you to shrink it. I'm just pushing. I kind of like the idea of having a drainage area that's also could be used for some sort of passive recreation as well.
You know, I have no problem with that. That's what I'm
And,
saying. Right now, the pond is encroaching into the. It's much bigger than what was shown in the concept.
It's kind of one of the notes that's in our packet tonight about this, where there's some changes that have kind of sacrificed the usable area for open space because of the enlarged detention pond.
Well,
So
also do the fact, along the southern edge of that detention pond, there's an existing sanitary sewer trunk main.
Can you slide us over to that detention
I can't
pond?
figure out
You're working on it.
But I
Ask
did.
Jack. You got a millennial next to you. I bet he can figure it out.
Yeah. Go up, more power to you,
I
brother.
actually had a really good meeting with First Utility, and the sanitary sewer main that goes through by the grocery store in that area. And I told the developer this today, is we're going to relocate that main to run along Kingston Pike and go around
You're talking about the sewer?
the sanitary sewer.
Sewer that
Yes.
goes all the way up to Ace Hardware.
Yeah, it goes up past Ace Hardware.
And you're going to route it out to Kingston Pike?
Yes, because it's a trunk line, and there's nothing coming
Yeah, I
in
don't know
on that,
what's doing.
where it goes through the property. We're going to route it through Kingston Pike and around back down.
Just probably going to have to be on Kingston Pike?
It won't be that deep,
Use
because it's only
the
6 foot
escape
deep
button.
at Kingston Pike right now.
Middle of that to go.
It's going downhill to go across.
Okay.
So we can, in fact,
Oh, you're saying you have too much depth as it is right now. You don't
Yeah,
need that
well-
much depth to have your fall. Okay.
the way we're putting it right now is, what this concept plan doesn't take into consideration is the sanitary sewer line that runs basically right underneath the detention pond.
Hence the reason why you're relocating it.
Yes.
Okay.
And I've had a meeting with First Utility. They do not want their pond, they don't want a storm pond on top of their sanitary.
I don't like anything on top of the shed. Why don't you guide us through what's happening here, Mark? And don't spend a whole lot of time on this if this is not representative of what you're thinking about building.
No, that's what we hope to build, is something similar to that. It just that I drew up, when I went in to put contours in, because I haven't done all the drainage calculations yet, is I drew in bigger than what I thought we need, and I'm hoping I can shrink it down, because right now I have, that pond's only about showing to be about 4 or 5 foot deep. My pond right now is about 8 to 9 foot deep. So if I can shallow it up and shrink it down, I'm going to shallow it up and shrink it down and make it less invasive. Because what I think, Mark, correct me if I'm wrong, what you're looking at is where the gazebo and the grass area is to the right side of that You would like to see it to be about that size as opposed to what is shown right now because the storm pond is encroaching into where the gazebo is right now. The way the plan I have right now.
It's just misleading when you look at that. It looks like a much more functional space than what was on the original site plan drawing. I know you're modifying that,
Yeah,
but
yeah.
that's
And
that's the disconnect there.
And well, part of that is these guys that put this together didn't realize that on the left side of that, there's a sanitary sewer line that goes through there that we can't put 14 foot of fill on top of. Anything over 10 foot deep, I have to get special permission from First
Back in
Utility.
December, you got more, concept plan is a very different level of information than a site plan. And, you know, you're kind of wanting to have your cake and eat it too. You got a concept plan, but now you're not wanting to follow it.
Is this what we approved on the concept plans, what we're looking at here?
That's-
So what you're saying, what has happened through engineering, your volume requirements for your detention pond are actually going to be larger than what?
I'm hoping it can be that size, but until I get done with the calculations, I don't want to promise anything.
Do you have
I
other
can't
ways
get.
to mitigate your detention?
I am trying.
Okay.
The problem is in this pond is going to be handling basically the apartment complex, and there isn't a lot of areas in the apartment complex that I can put storage in because of the slopes to keep the apartments up as high as I can so I can minimize the retaining walls on the southern side of the property. It just doesn't lend itself to it very nicely, and I'm trying my best to minimize the stormwater impact on this.
Well, what's attractive about this is that you're able to have dual uses for an area, and
that's
we
what I
like
wanna
that.
do.
And kind of what I think about, which is an extreme, and with an unlimited budget, so I think about the area at Seaside, Florida, that has a detention pond, but then they also do their concerts in. And I'm not asking you guys to build a stage and things like that, but that's what was attractive about this plan early on.
Yeah, and
is that you have something that was I've seen 1, 2, 3, 4, 5. 4 risers there, so you only a couple of feet deep, and it's kind of comfortable. Obviously, when it's raining and there's water in there, nobody's going to be out there. But the idea is, after a day or so, it dries out, and you're able to use it again. But I think this was one of the things that was real attractive to me, to be able to address this functional open space.
And that's what we want to do.
And I'm not even sure if this is not what you're proposing. I don't even really want to look at this because this is nice and neat and pretty to look at, but it's irrelevant until we see something that kind of what you're saying.
Well, again. The landscape architect who did this, and I sent him the CAD file that showed the sanitary sewer, and it didn't even take the sanitary sewer into consideration.
Okay. Well, you might remind him that's actually a detention pond, not a retention pond.
Yeah, it's a detention pond.
Right.
It's not a retention. We're not holding water permanently.
You just tell him he's not a civil engineer. He should know better. So.
Yeah. Detain, you slow it down. Retain, you
Reason
hold it forever.
And
we don't want a permanent pond there.
I've done a lot of talking here. I'm getting comfortable with this open space and where we're heading with this. Now I'll be disappointed if all this is a detention pond next month.
It won't be.
Okay.
I'm trying to minimize it down to the bare minimums.
All right.
I mean, I think when you see the next grading plan, it's going to be significantly different. And I actually like the idea what you came up with this on the other common space one between the apartments and the grocery store. I think that's a good combination, is to split the retaining walls for that common space area, because as one who was thinking about it, what Louise, and we talked about this in the parking lot after the meeting last week, is if you have it all up on top, then when you're standing in the grocery store, you look over, you're looking at a 13 to 15 foot retaining wall. That's not, no retaining wall. I don't care how pretty a retaining wall you build. It's not pretty. And even if we have a 5 foot grass strip there, we put plants and shrubs and stuff.
It's also intimidating when you look at all those steps.
Yeah, well, and on top of that, you have to put a handrail all the way across the top of that.
Well, you're still going to have to have safety rails.
Oh,
Either
you
which
still
way.
have to have safety rails.
But I think you're going to make something more usable. Let's kind of focus back on this so we can kind of work through some of the items. Because our goal tonight is to give you guys enough direction that I think you'd like to have this heard on next month's agenda as an action item.
I would love for that to happen, but I have a feeling it's not going to be that way.
That won't be. We can do another workshop possibly, but we've got a complete new re-review at the staff level, and that's not fair to the staff.
Okay.
Because I haven't
You're saying
seen
the changes are
and I
significant
think Mark's
enough.
still probably, in fairness to him, he's probably still trying to tweak out some of these things too.
I'm trying to get some answers to some of the questions we have. And
Big complex site.
There's
a lot of facets to it.
It's a very complex site. And
Okay.
I agree. And let's put it this way, I may propose, and I think Daniel's going to probably kick me in the butt for saying this, but let me get it to where we submit stuff so that we're on the full agenda, not next month, but the month after.
I think that might be reasonable to work it out. We could have it under staff developer if you wanted to, if that would help you all.
Well, yes, I think so.
Because I want, when it comes back to y'all, I want it to be pretty,
Right.
pretty complete.
We don't need it loosey-goosey anymore.
Yeah.
And quite frankly, we'd like to see you guys get rolling and stop having this on our agenda.
Yeah.
So.
What, you don't want another overlook at Campbell Station?
No, where we deal with it for a year.
Which
So-
actually, just for y'all information, I have a meeting on site on Monday to kick off the grader on that site. So, yeah, and
Large retaining wall, if it gets to this level.
Are there some other items? I'm looking at number 3. Have we addressed number 3?
I don't remember what number 3 is.
Number 3 is about connectivity to the west. We touched on it about having a.
We'll show we have no problem showing an easement to going to the west.
You probably
With you, Mark?
And you probably need some other thoughts from the planning commission to see if everybody else is. I'm personally satisfied with that, but I'm one.
I just think it needs to, you don't need to preclude it from happening in the future if conditions are favorable at some point. But it needs to be realistic,
I agree.
obviously,
No,
where you're tying it in,
When-
or you
when we-
might tie it in.
When we did the concept plan, we agreed that on the southern end of the loading dock area, we'd show a 50-foot easement to connect over to the west. We'll show an easement there.
I would recommend stubbing it out to that point.
You mean, now I gotta put a retaining wall on the property line?
Well, again, that goes back to my thing, it needs to be realistic. Wherever you make that tie-in needs to.
Well, then, if you want to do a realistic tie-in, it'll be right by the parking in the middle of the back of the building.
Which
Nobody
wants that. I don't want to tie. I don't want to, be back there by the dumpsters and the trash compactor.
There is no dumpster at this grocery store.
Okay.
It's all
That's
in the
really
loading
up
dock
to you
area.
all. I mean, if there's not a logical place for it to happen, that's really your
And I can't
all's
ever really
call.
see it tying into those adjacent properties, being the way that they're developed today. But nevertheless, I do think we need a platted easement. So, in 30 years, somebody may tear down those storage units and do something else.
And they'll have to build that whole area up about 30 feet to do it, to make a connection.
Then it is what it is. But at least that connection will be there platted.
And we'll be more than happy to plat the easement. That's not a problem, planting an easement. But doing a stub out is fool's gold right now.
Yeah.
Okay, Mark, have we touched on all the issues that you?
I think all that they ask us to look at, and trying to,
Okay.
again,
And
keep it
Mark,
focused.
have we touched on
as far
all
as I
your
know.
issues?
You've given me some really good direction, and like I said, I think it might be better for us to just sit down now and finish the plans and address all the staff's comments, do a resubmittal for February for a March meeting for full approval.
I just have
Go ahead.
one comment that's not related to any of this. In earlier meetings, you had said that the grocery carts would be parked in front of the grocery store.
There's some that will be parked in front of the grocery store, yes. That's the way they operate.
I think you go. How can you disguise those so that's not the first thing you see?
Oh, that's a darn good question. And I am not an architect, and I don't know how to do that, dear.
Is there not a vestibule?
There is a vestibule in this, but the front doors go right into the vestibule, and you go right in the store.
Vestibule not allow for cart storage?
Some storage, but not all of it.
You're saying when they're, senior Wednesdays, they need
Yeah.
all the carts and they
Yeah.
all won't fit in the
They won't fit in the vestibule.
vestibule.
So it's more like a Lowe's or a Home Depot entrance.
Yep, it's going to be more along that lines.
Or a Publix.
Yes.
Well, think on that.
I'll be more than happy to. And I know Mark is still wanting me to figure out a way of putting some more landscaping along the front of the grocery store, but
Yeah, they need a lot of landscaping there.
I mean, food for thought is the way Publix does some of their parking lot storage, where they've got these just dedicated little lanes for, I'm talking about shopping carts.
I understand.
They're a lot better than just having this, galvanized thing thrown out in the parking lot.
Oh,
and I don't know how that would accommodate you here, if that's even, but it seems like that's just a lot better way, at least somewhat, you can get some landscaping near it instead of just being thrown in the middle of the parking lot.
Well, and I think Mark will jump on me for this, but the only place you put those is in landscape islands, and we're already he's already asking for more landscaping than what we have right now, and we're barely making the parking requirements as part of their agreement with the grocery store for things right now, so I can't afford to give up a parking space.
Well, you're going to give up parking spots for cart storage somewhere.
Yeah, that's
when they put their galvanized racks out there.
That's where they dictate that to me. I have no control over that. And I agree, they're ugly. There's nothing about a cart storage rack that's pretty. I agree.
You'll find them everywhere, too. Anywhere they can be rolled, you'll find them down on Kingston Pike.
You're going to find them at
Yep.
Lot Road Park.
Oh, I agree. Grocery carts are a menace. But when you're walking around the grocery store, they're a wonderful thing to have in front of you.
Yes, they are.
I think Mark Shipley said that there's still some landscape requirements in the front of the building that you're going to try to resolve.
We're trying to
and there
work that
might be a
out.
way, like with Kroger, they have now their raised flower beds need some TLC, but there might be a way with some flower beds or raised flower beds or something like that to be able to at least somewhat disguise the shopping carts that are being stored out on the sidewalk.
On our grading plan right now, as you come in next to Y12, that first corner of the grocery store is about what is a concrete area right now is 4 foot above the grade of the ground around it. That's a retaining wall right there.
Where that little crosswalk is?
Yeah, no, actually, and I've actually moved the crosswalk up a little bit so it doesn't come into a retaining wall. Yeah, to deal with the new topography. Yeah.
I mean, I wonder if there's a way that might be, since that's going to be a little no man's land sitting up there on a little plateau.
Yep.
Maybe there might be a little way for some cart storage just to be kind of out of sight, out of mind behind a little, little brick privacy wall or something.
Yeah, we'll talk to the grocery store architect to figure out how we do that.
You won't be able to really use that area.
Well, that's the only thing it can possibly be used for.
Is cart storage.
Well, they also have an emergency egress right there too.
How are you going to deal with that with 4 feet of fall?
Well, they can go towards the store and come out at grade. By the time you get to that little pull-out area, we're at grade.
Okay. Anyway, we encourage you to try to be as creative as you can.
I'll be as creative as I can get away with the architect for the grocery store. And I thank you all for your time and your patience.
Thank you.
Thank you.
Ed, I appreciate you.
Final item is discussion and public hearing on amendment to the Farragut subdivision regulations as they relate to grass strip widths between streets and pedestrian facilities, plan submittal requirements, connectivity, and street standards. Town of Farragut applicant.
We've talked about all this stuff really at a number of planning commission meetings. Most recently, back in November, we had some items that we mentioned at a workshop session, and it's basically, as you all know, we've made some amendments to our zoning ordinance to try to address the appearance of sites, parking lots, and things like that, to help implement different aspects of our land use plan and our architectural design standards. It's something that the staff's been talking with the commission about, is also looking at our public rights of ways and trying to look at them in a different way, maybe a way that probably no one in the area does, but I think should. And that is to try to figure out ways to make them, placemaking spaces for all different types of people movement, not just a street, for car movement only. And so the amendments that are part of these two resolutions, and I apologize, the numbers were incorrect in the packet. I didn't realize that there were some previous resolutions that had gone to the board. So it's actually now resolutions 1803 and 1804. Resolution 1803 talks about amendments to Article 2 of the subdivision regulations. That's the section of the subdivision regulations that mainly deals with what you have to submit for plans, concept plans, preliminary plats, final plats. So something we've talked about a little bit with some sites that have come before you all is how can we maybe beef up our physical inventory requirements so that we have a better look of properties and what they have to offer early in the design process, so that they're trying to create developments that work with and not against the land, and try to capitalize on what the land has to offer. So we've made some adjustments to existing language as far as the requirements for concept plans and preliminary plats, that where a concept plan may not be required. We've clarified that a steep slope is a slope steeper than 15%, because that's always been kind of a gray area. What is a steep slope? We just added some clarity there. And make it an actual plan sheet that is prepared by professionals that have expertise in what is being shown on the plan, or at least verify it. So by making it a specific plan sheet in the submittal, it kind of elevates it to a level of importance that I think it needs to have. And that's one of the things that we're recommending in 1803. Another thing that we're recommending to try to encourage a more creative and innovative approach to how we use our rights of ways, and make them visually and functionally desirable, is to create a requirement for a streetscape plan as part of the concept plan submittal. It would be a plan sheet that would again be elevated in importance to other traditional aspects of subdivision development. How are you going to make your development unique, have an identity? A place like Island Home or Cherokee Boulevard, or even the cottages at Price Farm, a development here in the town, has a uniqueness to it, an identity. And we don't have a lot of land left in the town. From a staff's perspective, I think everything that comes before you needs to be at the highest level possible. And that's what we're trying to encourage with the plan submittal process, is to make the designer walk the property, get with the staff, look at how it's presented, how it's going to look in 20 years to the community, because these things provide lasting value to the town and a developer, and they stand the test of time. And also as part of the transportation element sheet that's typically submitted with a concept plan, is to address specifically how you're going to create by design in the subdivision basically traffic calming system, so that you're looking at not creating a situation that's going to need to be calmed in the future. You're calming it from the start through the design. That's the basic changes that are proposed in Resolution 1803. And what we're trying to create is something like this, that has lasting value. It has, it's very inviting, very appealing. The places that people refer to, whether it's Savannah or Island Home or, wherever, it's these things here that people have paid attention to when they did those developments that have stood the test of time. And that's what we're trying to encourage with new developments that come before the town. This particular development, it's a newer development, but you can see a lot of the elements that we're trying to encourage with the plan submittal. You got the wide grass strip, the curvature in the roads, rear-loaded houses. There's kind of an engagement with the street there, even though it is kind of a newer type development. So it has a lot, a lot of things going on and a lot of things to offer the community that are very marketable. I've talked to some builders in looking at this comprehensive land use plan steering committee I've been involved with, and there's a real disconnect between what people want, especially millennials, and how they're actually living their lives. There's not the product out there that is being offered. So what we're trying to do is look at these things in a different way and try to provide that product. This is an example of what might be included on, for example, a streetscape plan sheet. You're just simply identifying the different things that you're providing to make that street visually inviting, appealing. It could be a variety of different things. And that's basically what Resolution 1803 is. I guess I'll just take, if you have any comments on that resolution, then I'll go into 1804 after that. Yeah.
Question about who maintains that outer area.
Well, it's just like it is now with these kind of amenities. Typically, it's the homeowners association, and like in the cottages at Price Farms, that the beautiful boulevards and things they have in there are maintained by the homeowners association.
That's how it's in Fox Run. That's how the boulevard is maintained by the HOA.
And there's a lot of flexibility in the language. We're not asking you have to do the same thing. Just look at it and think about it on the front end and how you're making the thing look nice and look presentable. And not create situations where you're almost making people speed by design. You're thinking about that on the front end. We've been doing this when we've had plats come before us. We're just trying to formalize it through these resolutions. Does anybody else have any questions on that one?
PC-18-01 is now PC-18-03?
3, yeah,
Okay.
it is.
I do have some comments about this particular amendment. In the town, we are going to continue to deal with more subdivisions that are smaller in scale than we've historically dealt with. The one that we just approved on Old Stage Road is a good example, about a 5-acre subdivision, 7 lots. I think the requirement on small subdivisions to have 2 accesses to public roads where it's not feasible, when I mean that you don't have a willing and able adjacent property owner that's going to allow you to tie into it, my opinion is that we should tie it to the fire code that the town has adopted that basically says if it's over 30 houses, is it 25 or 30 houses, Mark?
30.
30 houses, then we should have a requirement for that second entrance. Now, there are some ways that you can sprinkle the homes with fire suppression sprinkler systems to be able to mitigate that requirement, and I think we should leave those requirements alone. But my thought is we should mirror this with our fire code that we currently have adopted that says, hey, if you're over 30, you need to provide for a second entrance. Obviously, if there's a budding piece of property that has a stub, we need to make them tie in. If there's a right-of-way that is logical to tie into, we need to make them tie in. But I think just by having the requirement that says, the houses of existing lots less than 1 acre, I think that's a real hardship to tell somebody, well, just because your neighbor sits on an 1.5 acre lot, we're now not going to allow you to develop your 5-acre piece of property because your neighbor's not willing to sell you a 50-foot right-of-way through their property to get to the next street over. So I think that's mentioned in a couple areas. It's mentioned in the 3rd paragraph in section N. It's also mentioned in the 3rd paragraph in section Q.
Well, it does, not to disagree with what you're saying, because I don't really have a problem with it, but it does say the Planning Commission may waive this requirement in cases where all the surrounding properties are existing house lots of less than 1 acre or where very significant topography. So it kind of refers to it, but you think it should,
I can think
even
of places,
despite that language, it's not.
I mean, I can think of a particular farm that was on Union Road. That was a 25-acre farm that there was one way in and one way out, and it backs up to Fox Den. It also a builder ended up buying it and keeping it a farm, so it's a non-issue at least until the subsequent owner goes and decides they want to develop it.
Yeah.
And there are some properties that back up to Smith Road that are over 1 acre. And so all of a sudden, due to those constraints there, we would have to tell them, nope, you cannot develop that. And we as a planning commission don't even have the jurisdiction to waive the requirement.
Okay.
Because your neighbor happens to be over 1 acre.
Okay.
So my thought is if we tie it directly to the same language that's in the fire code that says anything over 30 lots. Now, if we want to put an acreage requirement on it, this is a juncture that we could do that. But my thought is it just makes more sense just to tie it to the fire code. So any neighborhood over 30 lots, that's going to get triggered by both the fire code by having a secondary entrance to a public road and our subdivision regulations. And they're going to mirror image each other. So there's no, well, you got to follow this code and you got to follow this code, and they're different codes.
Yeah, I think that's a point well taken. I understand what you're saying. The thing with that was we were trying to look at, and we can modify that language to either base on acreage or the 30 lots. But if you've got more than an acre, you don't necessarily have to make the connection, but you have to provide for a stub out so that if that tract over an acre were to be re-subdivided or something, that there could possibly be a connection between the two.
Well, that's actually not how it's written as proposed. How it's written as proposed, the subdivision shall have more than one public street vehicular access into and out of the development. It doesn't give us the flexibility to plat a future access. So if that is our intent to have that type of flexibility, we need to write it in the ordinance.
Yeah, we could tie it to the fire code possibly. Dan did look at this language. I did share it with him.
Well, which one do you want? Do you want to have a plat for a future?
Well, I think what the underlying goal of our planning commission and the staff is we want connectivity. We don't want to be a town full of just all cul-de-sacs. There are times, and there's some language in here, where cul-de-sacs are appropriate and they're permissible and they're going to be short, but they're not going to be these long cul-de-sacs like what we have. And again, this all goes back to the open space about splitting the difference, of trying to create a sense of community and not just have all of our neighbors just all isolated in these little pods. So I think the intent of what we're trying to do is great. Yeah. I think there's a domino effect that is an unintended consequence of what we're doing here that could be real dangerous to a lot of parcels that we're going to deal with in the next 20 years. Yeah. And we're not dealing with the big 300-acre Bridgemores anymore. Yeah. We're going to be dealing with these smaller parcels. Mm-hmm. And I think when to me, the difference between a small subdivision and a large subdivision, that magic number is 30.
Okay. Understood. Works for me.
So we could say, for purposes of just modifying this, let's see here. Any subdivision with more than 30 dwelling units or house lots shall have more than one public street vehicular access into and out of the development.
Bingo. I think that's perfect.
Would that work?
Yes, sir.
That doesn't mean that y'all wouldn't potentially require it for a subdivision with fewer lots.
Absolutely. So. Yeah, we're still gonna push the connectivity real hard, okay. Even if it's if the one that backed up to Fort West that we just approved a month or two ago.
Yeah, right.
If there was a reasonable way to be able to get a connection, other than we did get a pedestrian connection, but if we could get a vehicular connection, we're going to make them do it.
Yeah. Yeah, and that was a good example where it would have met the language proposed because everything was in platted house lot around it.
Right.
Yeah, we can add that language. I think that would.
So you're saying how you want it.
We're going to force the requirement on subdivisions greater than 30.
Okay.
Just like kind of what it pretty much mirror image exactly what we do with the fire code.
Well, let's go back to the horse farm.
Yeah.
So if they're
that would be limited to 30 lots in there because of one entrance. Okay. Unless they could figure out a way with one of their neighbors to be able to put in another access. But at least we're not prohibiting them from developing it. We're going to say, hey, look, you might be eligible for 50 lots under general zoning. Well, I think that was R2. But being that we require 2 access points, there's a lot of reason why. I mean, the big thing is life and safety. But we require 2 access points. We're going to limit you to 30.
Okay.
Instead of just saying, no, you can't develop any.
Okay.
Which farm did she say?
I'm sorry?
Which farm did she say?
I can't remember the name of the. I want to say Huntley, but it's not.
Yeah,
Huntley.
it's a Huntley property.
It was Huntley. I was okay.
Yeah.
Oh,
it's on the other side of Union.
It's over on Union Road, backs up to Fox Den.
yeah. 20.
Yeah, I can add some clarification on that one. And that does appear
I think we need to be careful
different.
not to have these through streets turn out to be thoroughfares through a subdivision.
Absolutely. And that's why we have
That's gonna happen.
that's exactly why that traffic calming plan is something that we're recommending as a requirement. Because if you do have a stub out like the one at Saddle Ridge, the best thing they could do right there is for that, as soon as you get into
Do a
the
dog
highway
leg on it.
property, is it either needs to take an abrupt
A dog leg.
direction in one way or the other, so that you're not, by design, you're not inviting somebody to
And if you do it
cut
in
through there
that
fast.
village style that you have put out here, then you really make it complicated for someone to use it
If you're
that
providing
way.
more connections and more intersections, you're providing a more connected community, which is more collectively integrated, and you're also slowing the traffic speeds. And people have more than one way to get around and throughout the development. So they're not all coming out to one location like we have a lot of in a lot
ton
of
of
places.
subdivisions.
And
I mean,
we're not
Fox
the
Run,
only one.
Think of the
It's-
number of houses that uses one subdivision.
When I fly in an airplane, I look at these things as a planner, and it's amazing how many cul-de-sacs and developments are that are you just like, if they could have just did this and all this stuff. And I'm not against cul-de-sacs necessarily, but I just think there's a place for them potentially, but.
Well,
as
you limit the size of it. I was trying to think of how
Yeah.
many houses you could have on a 500-foot length cul-de-sac. Probably maybe 10?
Probably 10. I mean, that'd be like R1 lots. If you had 100-foot wide lots and you double stacked them.
Yeah.
So
I will tell you, I live on a cul-de-sac and a cul-de-sac, and that's the reason why I joined my HOA, because I didn't know anybody outside of the people that I lived right around, because we weren't part of the community.
it's a push-pull. I mean, cul-de-sacs are desirable.
But
Starts out, I don't want to know them.
yeah.
Would I, on that, and it makes some good points there. If we could change that, are you all comfortable taking action on that resolution? Was anything else? Did y'all have any other questions on that? I think Bart and I can come up with some language. We can report back to you all with that. I think we understand what you're saying. But I'd like to go ahead and try to get these things, if you all are comfortable with it, adopted so that we can start requiring them, because they need, from the staff's opinion.
You'll need to send them on to the Board of Mayor and Alderman too, won't you?
No, not these, because
not
they're
subdivision
subdivisions.
regulations, just the
Yeah.
zoning ordinance.
Yeah.
Well, I mean, if we're gonna approve it tonight, we need to go ahead and wordsmith it, don't we?
Yeah, we can do that.
I mean, I think by inserting the two words 30 houses, greater than 30 houses, I think that, or 30 dwelling units, and I think that's our intent. So I guess if somebody did duplexes, it'd be 15 duplexes, but I think dwelling units is completely appropriate, and that's a term that we've used pretty widespread throughout the subdivision regulations.
Let's see.
It goes in at that and at
We
Q.
go third paragraph or subparagraph, whatever, the third paragraph in N and the third paragraph in Q.
And it's also in the next resolution too, under the connectivity section that we added.
Right. And that's actually what we're adopting tonight, so.
What I want to make sure about is that there's some language in there that does give the commission the ability to require it for the appropriate subdivision that may be less than 30.
Well, we're obviously
dwelling
hanging our hat on that language today. Where is that language? I mean, because we already do that. I mean, but if we need to codify it officially, then let's do it so there's no ambiguity.
That's exactly what I'm trying to do with these things, is get them more formalized so that people understand. There's less subjectivity. Let's see.
Well, how about this? How about we take the 30 greater than 30 houses and we put that actually in the sentence about waiving the requirement. So the Planning Commission may waive this requirement in cases of where all the surrounding properties or existing lots are less than 1 acre, comma, where very significant topographical issues exist, comma, or neighborhoods 30 dwelling units or less.
Okay, yeah, I think that's good.
And that way you've got a catch-all. I hate to use the term catch-all, but that's what it is. We've got a catch-all to say, hey, you've got to have a secondary access. There is some room for relief if any of the following criteria are met. And that's where we catch the 30 or less.
Yeah, okay, I like that.
Where are you sticking that word?
Well, we have changed it, and basically what we've done is instead of putting in the requirement, we put it in the sentence that waives the requirement.
Right.
So the planning commission may waive this requirement in cases where all the surrounding properties are existing house lots of less than 1 acre, comma, where very significant topographical issues, comma, not created by the design is, boy, that sounds like a big run-on sentence now. But what I'm trying to do is add that third item in there, however you want to put it in there.
Yeah. Or subdivisions with dwelling, with
30 or less dwelling units. Because
Yeah.
that ties in directly with that fire code.
But we don't have to mention the fire code in this?
No, I was just doing that just so the staff doesn't have to, tell, well, fire code says 30, but we require 25, and that way all the staff's reading off the same page. It's when somebody comes in, a prospective developer with a concept plan, all these things are going to be relatively easy. Say, well, you're 40 lots here, that's going to create an issue because you can't get a secondary access.
All right, we can make that change in that, where that language is in both of these resolutions. Anybody else have any other on this resolution first?
I'm just going to do for clarity. I
Okay.
feel like I'm Roseanne here. Should it read, the planning commission may waive this requirement in cases where, 1, all the surrounding properties are existing house lots of less than 1 acre, or 2, where very significant topographic issues not created by the design of the subdivision would effectively prohibit connections, or 3, neighborhoods with 30 or less dwelling units. Does that clarify it?
Sounds good to me. I think to avoid that big run-on sentence, I kind of like the way that Louise has put it, where you've got 1, 2, or 3, and they're not ands, they're ors.
Yeah, okay.
Yeah, we would probably change
Exactly like
neighborhoods
what
to
she said.
subdivisions.
Subdivision, sorry.
Does that make sense? Okay.
Subdivisions, what I don't want is some guy coming in and just platting 29. You know what I mean?
Well, I mean,
that's going to be based on their concept plan.
Well, keep in mind, it's still up to the planning commission. So we've left it up to the planning commission. So if somebody comes to us with 29 lots, and they can get a secondary access,
Get 29 and
they can get a secondary access, we're going to say no.
Yeah.
Okay,
I like how
that's good.
That's good. I like that.
So you want the 1, 2, 3?
Yeah.
Okay.
With ors, those are ors, not ands.
All right.
And again, the key word is the planning commission may waive this requirement if one of the 3 following things are met. So I think we've got it covered there.
Okay. Good.
Wasn't that 3 choices?
How about you just craft whatever you just said into a motion? I think we'll be good.
Yes. And
Do I need to put the amendment in my motion with the amended language or do I need to say the amended language?
you can say it if you can restate it.
Oh, I'm glad you're doing it, Louise, not me.
I move to approve resolution 18, what is this, PC-18-03, with the amended language to Article 2, do I need to do that too? Section 1, Article 2,
Well,
Article 2.
subsection N, is that what it is?
paragraph.
To amend the sentence to, I don't know how to do this. Jeez. I'm just going to read it. The Planning Commission may waive this requirement in cases where, 1, all of the surrounding properties are existing houses, lots of less than 1 acre, or 2, where very significant topographic issues not created by the design of the subdivision would effectively prohibit connections, or 3, subdivisions with 30 or less dwelling units, period.
And the only thing we need to do is insert that into Q, and then technically
And then
To do it again.
we'll have to do it again in the next resolution.
we'll do that in a whole different action item.
In the next.
O2. So I'm going to second Louise's motion.
Yep. Okay. I got you.
You got it.
Got it all?
Yep. I think I got
Okay,
it.
we've got a
Yep.
motion and a second.
All
All
right,
those
that
in
was-
favor? Aye. Opposed?
Okay.
What's the new number of PC-1802, Mark, before you get started? Is that now going to be known as 4?
That's 04.
Okay, that's
yeah, and
04.
again, I apologize
No, that's
for
okay.
that. That was my fault. The 04 is talking about, and that's Article 3, that's the section of the subdivision regulations talking about improvements. These amendments address transportation-related aspects of subdivisions to try to promote certain aspects of our land use plan and our design standards to make them more interconnected. So it's, there's some language in there about really kind of discouraging, though not prohibiting, but discouraging dead-end streets and trying to encourage more integrated street networks for a variety of reasons. There's the new section that we just talked about with requiring connectivity, which we'll amend. And then, as we talked about in November, and we had the development on Old Stage Road was the first one to do this, but we talked about increasing that grass strip width on local streets from 3 feet minimum to 6 feet minimum. And that gives, you more space, obviously, to realistically plant street trees that would be potentially shown on your streetscape plan. And it can also just kind of give you, if you can get that incorporated along the rights of ways, it can help also slow traffic because there's a perception that you have some enclosure in that space, and people have a natural tendency to drive a little bit slower on heavily tree-covered corridors as opposed to very open corridors. So that can help us to address the plan requirements that we talked about in the previous resolution with traffic calming. There's also a clarification in this resolution that really reflects our current practice in terms of lot frontage widths. In the OSR overlay, there's not a requirement on non-cul-de-sac lots for 75 feet of frontage. And that's a little bit misleading because the subdivision regulations kind of imply that that's a blanket requirement. So this is just some cleanup language to reflect our current practice, that there may be some other areas in either the subdivision regulations in the future or in our current zoning ordinance where there's a reduction in that frontage width. We may want to reduce that to encourage rear-loaded dwelling units in the future. So that gives us some flexibility to make those changes to the frontage requirements. So I think with the modification you all talked about addressing the connectivity, everything else we've talked about in the past, I believe. Do you all have any questions on this resolution? And we'll make that, obviously we'll make that change to the connectivity section that's being proposed here.
Madam Chairman, will you entertain a motion?
You got your wording and everything you want?
I'll just use the same, basically the same
Okay.
language, yeah.
Have a motion?
So moved.
Second?
Second.
All those in favor? Aye. Opposed?
That's all I have.
That's all? Then that,
A question, Mark.
Okay. Oh, yeah, we do need to talk a little bit about that, don't we? I forgot. I mentioned also there were some things that we didn't. We were trying to address the low-hanging fruit we talked about in November. Then there's some other things in our subdivision regulations or our design requirements that I don't have a good answer to right now, like if we're trying to encourage low-impact development. And maybe this streetscape plan will start to see some more of that type of stormwater management application, but just be thinking about if we should be, trying to require that kind of like we do with site development, and if so, should we just do it through incentives and maybe give certain developers some reductions in certain requirements in exchange for, doing some low impact development applications in their developments. And I think we also, and this will be something that we'll be having some public meetings on, is just how we present our street standards in the subdivision regulations. When you go to them, if you're a designer and you see the requirements, you kind of you're kind of steered in a certain direction without really thinking about the context of where you're designing potentially. So one of the things that we've already talked with you all about a few months ago is probably looking at our collector streets, our substandard collector streets that we have left, and trying to get some community engagement on what kind of cross sections they would like to see for those, and then kind of make that more part of the subdivision regulations than just, you know, a blanket 12-foot lane and for the collector street, you know, that it really needs to be thought through with the context, both the present context and what we anticipate would be the use of that facility maybe 20 years from now based on traffic counts and things like that. So that's another thing that we need to probably think about. And then whether sometime in the future we want to consider widening our walking trails. It's 8 feet right now. I think TDOT's gone to the 10 feet. City of Knoxville, I think, is going to 10 feet. But I don't want to disincentivize somebody wanting to put a walking trail in versus a 5-foot sidewalk either. So that's why I didn't propose that change at this time. I think we just need to be thinking about that and whether we want to make that a requirement in the future, or just stay with what we have. So I don't know if y'all have any thoughts on any of those suggestions right now or workshop items, but that's some things we'll be talking a little bit more about in future planning commission meetings. Is that what you wanted to talk about?
I'd like to say is, I would like to see, I would love to see us do the community engagement and get the cross sections for each of these, eventually the substandard thoroughfares that we're going to improve. But in the meantime, I would like it if we showed some flexibility, perhaps particularly in our collectors. When we set them as 12-foot, Darrell is in a position when he prepares his write-up that he puts the 12-foot lanes. Well, someone who is not experienced in it just reads that and decides, oh, that decision's already been made. There's no sense in me coming in and discussing my concerns about that. Whereas if we have some flexibility saying a collector could conceivably be somewhere between 10 and 12-foot lanes, then at least we know that there's some an opportunity for discussion from the community, because one place a 12-foot lane might be very appropriate, and another place a 10-foot lane would be appropriate. And I think we just need to demonstrate that flexibility in our subdivision regulations.
Yeah, and that's kind of what I was getting at with that one, because it does have the same standards that's been there for a long time, which I'm not saying they're inappropriate, but they do kind of skew you to a certain design.
Yeah.
Because you don't see that there's potentially other things you could consider based on the context. So I don't know, that I was probably going to revisit that, I guess, as part of that cross-section adoption process.
Because that's going to be, if we want to do that right, that's going to take some time. And, and in the meantime, I think just amending these requirements in our subdivision regulations shows that there is flexibility until we can get it to all these. Because we want to make sure that we're engaging the public that actually uses those roads, and we're doing it in a way that, and we'll probably have to revisit it anyway. I mean, Evans Road is probably the next, after Virtue Road. Evans Road, to me, I think was the next one we had. I can't remember how is that right, Ron? So that's going to be a conversation, but who knows how it develops between now and then. So at least if we demonstrate it in here, it lets the residents know that this is up for conversation.
Have we already done the design profile for Union?
We've requested a design exception at 10-foot lanes.
Okay.
And I believe roundabouts at what would be the Ivy property, Swan property, and at Fox Run. I'm not sure where it stands on getting approval for
So
that.
that has to go through TDOT, has to give their seal of approval on that.
Yeah,
He's the,
TDOT
he
is
the
working
cost
through-
match or
yeah.
share.
They're working through new standards considering their multi-use transportation policy. So I'm hopeful that what we're asking for, because we want it to be walkable, is it will sway them. Because their standards is 12-foot lanes and a 40-mile-per-hour
Design.
and that is just, that's what Everett Road is, and that's just too fast for Union Road. That'll give us 45 miles per hour on Union Road, and that's just not appropriate.
Are
Good
you
news is
at,
we're going through this exercise now in anticipation of Virtue Road and Evans Road and some of these other ones down the
And
road.
Virtue Road is a very different road because there are no
There's more traffic on
houses.
Virtue, right.
And there's no houses on Virtue Road. It is more an arterial road.
You're right, there's not as many houses that are
Subdivisions,
right on
But
the
there
front.
aren't houses, whereas Union Road is a residential road as well as a collector. It's two different roads, and that's
They're
the thing.
definitely apples and oranges.
Yeah, we need to
Yep.
be, and that needs to be reflected in our subdivision regulations.
I like the flexibilities, that's what it's about.
Roundabouts,
Yeah.
Or you just on Union Road, or just, you mentioned 3 possible places for one.
We've mentioned a possibility of a roundabout at Fox Run, mostly because it's such a big neighborhood. And that road looks like it's going to be a straightaway, and we've got so much traffic coming out of Fox Run, although I don't know that it will balance, but it's certainly at the Swan Road Ivy property.
Makes sense.
Saddle Ridge, not so much is a concern.
Well, it's hard to get it to fit in there because the neighbors
Yeah.
across the street.
Yeah. So that was my suggestion.
well, I think the same thing we're asking developers to do on local streets internal to subdivision, like the streetscape and the traffic calming, ought to be applied to
Yes.
collector streets.
Well, we know it's a problem,
Yeah.
so I agree.
All right,
that was all I
anything
had.
else?
Is that it?
Okay.
So the January 18th, 2018 Farragut Municipal Planning Commission is adjourned. Everybody stay warm. Here is a,
It's going to be 53 this weekend. It's like I had escaped many years without having signage issues, and now I have them.
Have one.
Yeah. Well, you can't.